Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Is that correct?
Dati mihi Anglican police verbal copy. That's really not true. Oh, for Trump's sake. I didn't ask you to interrupt me.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Monday to you. Wanted to start off with a little Onlyfans to get the week started. I'm still dancing though, still dancing. Welcome. I hope everyone had a wonderful weekend. Let's jump back here. We'll go back to Onlyfans in just a little bit. But oh man, things are good. I think let me make sure everything's working on my end. Okay, I think we're good. Good morning. How's everybody doing? Is today the day we get the verdict? Possibly. Greeners first in chat. Greeners was so close. I think we were joking the other day, and I think Greeners took it as a challenge. But we were trying to determine if somebody could actually be first in chat and win with a super chat. And Greeners came very close, being the first person in chat and the third person in chat with a super chat. That's the soonest we've ever had a super chat, Greeners. So I can't give you the win as far as this first chat being a super chat, but that is pretty close. Thank you very much for that. Miss Violet, also welcome to the gallery. Good to see that yellow courthouse by your name. Welcome. Hope you had a great weekend. Did anyone want to report on their weekend before we kick things off, as we're waiting for?
I'm not a camel.
Waiting for everything to begin. Oh my goodness. Let's see. I've got to get a couple things shut down here. Where's this one? Oh, not that one.
The zombie apocalypse may be upon us.
Is upon us. All right. I'm not sure as far as the time.
This is not Burger King. People do not get to have it.
I'm not sure as far as the time, as far as how long the jury's been deliberating. A couple things that started. Friday we had a video that you guys apparently really enjoyed, which was we read the order from the judge in the Sarah Boone case where he said you've lost the right to court-appointed counsel. Bang. No more free lawyers. Apparently she has swiped left too many times on what is it called? Tinder tube or something. Law Tinder tube. I don't know what it was, but she swiped left too many times. There are no more swipes available to her, and now if she wants a lawyer, she can either A, be one herself, or B, can pay for one. But the problem is she can't pay for one, right? That's the big deal. She didn't have any money. That's why she was getting the free lawyer to begin with. Well, say no more. We have a solution. Let me share with you this gem. This is GoFundMe. Help Sarah Boone secure legal representation. I have not fired any attorneys appointed in my case. This is just a screenshot from one of her letters. Somebody named Justice League is organizing this fundraiser in for the benefit of Sarah Boone. It's with a heavy heart that I find myself making the desperate plea on behalf of Sarah Boone, the much maligned, demonized, and falsely accused victim of an unfortunate luggage mishap and the gross miscarriage of justice that ensued. Sarah Boone, an outspoken, intelligent, and fierce self-advocate, has been robbed of her right to a 9th court-appointed attorney. In a clear attempt to punish and silence her, the court is requiring her to represent herself unless she can hire her own attorney. Sarah does not currently have the funds necessary to hire the caliber of attorney required. Qualified counsel for Sarah Boone, an attorney who will accept her case, take on her representation, follow her lead, see, accept, and love her for who she is and for what she has accomplished. An attorney who will ensure that all stages of proceedings, Sarah feels cared for, confident, positive, safe, secure, well-regarded, admired, attractive, intelligent, artistic, capable, competent, witty, warm, charismatic,
going to address subject matter jurisdiction.
Accomplished, youthful, charming, adored, certain,
This
and
is not Burger
victorious.
King. People do not get to have it their way.
These are the minimum standards for the representation afforded to all criminal defendants, yet the court and its lawyers have singled out Sarah Boone to deprive her of the representation she deserves. In what appears to be an elaborate judicial plot to sabotage her, another judge in Sarah's family court case is depriving Sarah of alimony as well as child support payments while she's in jail. As citizens, we must step in. On behalf of Sarah Boone, worldwide fans, I implore the public to reach into their hearts and their pockets and do their part to ensure Sarah can hit the bullseye and emerge victorious at the end of this ongoing multi-year travesty. Please donate so that Sarah Boone can finally hire qualified counsel. Race to the pulpit, no intent. Don't stop believing. Excellence. Fight for your rights. Thank you. To retain practice means to engage the services of an attorney or counselor to manage a cause, at which time is usual to give them a fee, called a retaining fee. The act by which the attorney is authorized to act in the case is called a retainer. A fee is a payment made to a professional person, or I cannot do this with a straight face anymore. I'm sorry. Whoever made this, it's hilarious. It's hilarious, and it's working. It's working because we've already raised $5 of the $10 million goal. So there it is. So have no fear. Help is near. I don't know who did this, but I'm pretty sure Sarah Boone does not know about it yet, although she will after she watches this. So there we go. Did you guys see it the whole time? Yes, I think so. Okay. We're going to close that one down. Please don't donate to that. I think it's
Is that correct?
I think it's not a legitimate cause. Not that the purpose isn't legitimate. If you find a way to donate and you feel so inclined, I'm not going to say don't do it, but just don't do it to that one because I don't think that is really for her. All right. Let's see. Where are we at? We have a buffer. Maud Matthew Harris, Law PLLC. Just a Girl Baking, Shannon and hubby celebrated their 13th wedding anniversary over the weekend. Shannon and hubby, we've got Maud. So Maud Matthew and Just a Girl Baking was not a relationship. Those were both birthdays. And then Shannon and hubby celebrated their wedding anniversary. So we're going to sing happy birthday to Matthew Harris, one of our great legal friends at the channel and a moderator on this channel as well. Just a Girl Baking is also going to be included on that list. When I say we, I mean all of us. Please join with me in singing happy birthday. Warm up first. La 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 la. Sounds beautiful. Everyone at your places. Deep breath, shoulders back. Project to the back of the room. Blend your voice with those of your neighbors. Dancers, if they're ready. Here we go. Deep breath. Happy birthday to you. Happy birthday to you. Happy birthday, Matthew, Just a Girl Baking, and Caitlin Gibson. Happy birthday to you. And Caitlin Gibson's got squeezed in there somehow, Steven. Didn't want to miss anybody, but Caitlin, congratulations. We got you added in just in time. I'm not sure if we have anyone else. 32 years old, Caitlin, congratulations. To everyone who's celebrating a birthday today or still celebrating from the weekend, Matthew, we're looking at you. Man, did we sound good. Thank you. I realize there are a million places you can be, a million people you could be with to celebrate your special day. But you've chosen to be here with us. Thank you very much. It was a good catch, Adam and Steve. Thank you for getting us on track with Caitlin's birthday as well. Help yourself to free pancakes at Denny's before they go out of business, assuming They do. I almost went out on a date with my wife over the weekends to a restaurant. And you say, well, why almost? You shouldn't be proud of an almost going out on a date. No, I almost went out to a restaurant. Last time I went out and took my wife to a date to a restaurant, the following day the restaurant went bankrupt. That was like, what was that, Red Lobster? So now I'm hesitant to go. I'd love to go to Denny's and get some pancakes, but I don't want to like shut them down before you guys get your free pancakes. Anyway, welcome. We'll have to figure out what to do eventually. We'll fade the music out, but the party never stops. As you know, congratulations to all those celebrating their birthdays. You guys are, it's now Dead Lobster apparently. You guys are amazing. Let's see. We are, the Arby's filed for bankruptcy. You serious? Oh my goodness. Apparently they don't have the meat anymore, or at least not the cheddar. All right, that was good, huh? That was really good. Let's check in with not Sarah Boone, with Karen Reed. Yep, still going. The fan is still turning. So nothing has happened. We do anticipate something today, and by something I mean I think the jury's going to send a note to the judge. It's probably going to be fairly consistent with what they've said before. But I doubt over the weekend the jury rethought this and said, you know what, I'm changing my mind. I was the one holdout, or we were the three holdouts. We're going to, we'll flip on this one. I think it has been like 9-10 weeks. I don't know. It feels like about a year. And the jury members are pretty set in their way. They're not rethinking everything from scratch right now. So I think we're going to get a reading from the judge, and I think it's going to be a hung jury. Now, what's going to happen is this. The judge still has her, what does they call it, the Tui charge or something? No jokes about viral videos that are inappropriate. That's actually the name, the Tui charge. It's basically the Allen charge. It's what the judge reads to the jury when they are stuck. They're hopelessly deadlocked. They cannot progress. They can't reach a decision one way or another. They read this charge. The judge has not done that yet. She said, you haven't taken long enough. Get back to work. But that's a little different. The Tui charge is a little more formal. It's a little bit longer, and it's a little meaner. Believe it or not, it's a little more sting on the cheek with that. So if that happens. But lots of fan merch out there for this trial now. The fan has apparently developed its own fans. So you've got fans of fans, so it's all just only fans. But anyway, we're good. So where do we go from here? We have a couple things we can do. We can do some court hopping. We can talk about. Well, let me actually 1 second. Hold, please. Where'd that one go? Did I shut that down? I didn't mean to. I will reopen it. You guys don't know what it is, but once I open it, then you'll know. Okay. I will say, apparently many parts of the country are getting some much-needed rain. New Mexico might have been getting a little too much lately. I saw some flood warnings out of there. We got some as well, and we're just happy that it cooled down from like 100 degrees down to 78 overnight, which was great. We just want to make sure there's no letters from a one and only Sarah Boone. I don't think they'd be filed already, but we do expect some motions to start showing up from her, which might be treated and handled a little quicker. And still nothing. So we're good. All right, nothing on Sarah Boone today. Probably won't have anything on that front right now. I have questions. Judge will be mad. Randy Rabbit? I think the judge will be mad. The judge is frustrated. It's been, 9 weeks, right? It's been a long time reaching this point in the Karen Reed trial. And for it to come to naught, for the judge basically saying all the work we put in was for nothing, and now it has to start over, assuming they want to start over, that would be sort of frustrating because she's worked hard to make sure it got this far. Steve N says 9 months of me enjoying my sense of humor and forcing it upon you all. You're welcome. Steve N, that is awesome. Babs Austin says, so I could have had a baby in the time I've spent here. Had way more fun laughing and learning with you all. Hugs. Babs, congratulations on 10 months. Yes, you can look at what you could have done with this time. But that's great. Chris Wallace, member for 12 months. Yay, 1 year. Orange is my favorite color. It looks good on you, Chris. Even though I say color differently than everybody else, that's what I mean. I can't hear the accent when I say it. But all right. I think about just unofficially, and I've seen this a couple different places. About 75% of us are thinking there is going to be a verdict today, and I just noticed because Brandy on her channel has a poll that has the same results. So apparently, it's holding true across the board with a verdict. But I don't think it's going to be a verdict. I think it's going to be hung. Brandy is putting on verdict brows. I see that. I see she's donning them. Okay, if you guys don't follow Brandy Churchwell, hang on one second. Let me get this pulled up just 1 second. This is the greatness you're missing if you don't follow Brandy. Yeah, that's her right there, putting on verdict. Good hire. It's literally a thing. It's literally a thing. Anyway.
Call from Angela.
Good morning, Angela. How are you doing this morning?
Good morning. I'm doing good. How are you?
I'm doing just absolutely fabulous. What's new in your world?
Well, nothing much, but I am I'm calling about I caught up on the rewatch crew regarding Sarah Boone. Wow. Well, that was about the time.
Yeah.
Let's see how that long will last, if it will last.
I think it's going to last. I mean, first of all, I think that the judge did everything he needed to legally to make that stand up in court. This isn't going to be an appealable situation. So I think it's going to work, but Sarah's going to be pretty upset, and that means she's going to write a letter or two.
Oh, I can't wait to read that letter.
Yeah. Are you going to donate to her GoFundMe? I rather spend money on something more valuable. Yes, good call. What's your thoughts on the verdict today? What are the odds?
It has to be 5 days. Is too long? Seriously. And I'm pretty sure my friends are about ready for me to stop talking about the case.
If they don't want to hear details about the case, are they really good friends? Yeah. Family, you can't do much about, but yeah. All right.
I may have used a friend or two as a sounding board, so hence they're about ready for this to be over.
Let me get the Onlyfans showing in here so you guys can see. Forgot to put that up here. Box 1 will be 2. There we go. Now we've got OnlyFans showing. All right.
But I have a thought about this. We all know that feds are around the corner. Probably there are rumors that they have sealed the indictments, so they may start arresting people right after the verdict. And I think that's why the judge wants this to be over, because between now and then, if the retrial happens, that's a huge if. If it comes to hung jury, I'm talking if it comes to the hung jury, I think that everyone is well aware that feds are on everyone's heels, everyone but Henry's, because she's innocent, and they are about to start arresting people. Well, so she wants a verdict.
It seems weird that the feds would wait until after the verdict. I think they've got their own thing. They could care less about the schedule with the court. They could care less.
Yeah.
I imagine if there is a verdict and she's found guilty in that verdict, that it would be overturned if there were arrests moving forward. That just seems. It just seems like it would hard to have that stand.
I'm not a lawyer. I don't either understand that. But we also know that Michael Proctor did testify to a grand jury in February of this year. So it has been for almost a year, that grand jury. I don't know if it's the same or the different grand jury. Probably the same, because Alan Jackson got a hold of it, of the transcript. But we don't know. But maybe they want this to go to trial so they can use it against them, like against Michael Proctor and McAlberts, yeah. And I don't know what they're waiting for, but I do know that even though, let's say you do not start arresting people after this trial. I don't know if I mentioned this before, but I followed the Scamanda case. If you haven't, I highly recommend. It took feds. Oh, let me see. I think that the first search warrant was executed like second year of the investigation or third year of the investigation, and she was not put on the trial until like year 5.
The feds take their time. They really do take their time.
Yeah.
They're quite thorough, but it's one of those things that we can't see into. We can't. It's very closed doors. Grand juries, federal grand juries sealed. The courtrooms are sealed. Documents are, it's pulling teeth to get those.
I know the Scamanda timeline because there's a podcast which I recommend, done by some British woman, which I have no idea her name, but I know she was on the Olympics 2012. She did it with another investigator, and that investigator actually caught on that case, and she was the one who reported it to the authorities because she was like, something doesn't add up here. And that's how I know that 3 years from the day it was reported was first a search warrant, and then year 5 was arrest.
I have to say, I don't know if anyone would be arrested. I don't know if. I think there's clearly a very shoddy investigation that was poorly done. I don't have any personal insight to say anyone has committed a crime other than possibly perjury with some of the comments that were made on the stand under oath. But the feds aren't going to be chasing a perjury charge. They've got bigger fish to fry. So that would be local.
Well, I think the only thing that they can go after is the corruption, which is clear. I mean, this is the second case in Canton, so first time.
If they're going after corruption, it's going to be like a RICO case. Yeah. This is not going to be a single person that gets arrested. It would have to be multiple people involved, and it would be pretty widespread. I think. I don't know. I can't see this turning into a RICO case. No, because someone on Twitter said there is like that Sandra Birchmore case. There is this John O'Keefe case, Karen Reed case, and there is a third one which I don't know exactly when that happened, but apparently there is a third one. Maybe not Kansas exactly, but that area, So there is third case that someone dug up. And where it was like, okay, this case was also investigated by Michael Proctor and so on, or same people at least. Yeah, I will say that
it's gonna be,
if there are any arrests, a lot of decided cases leading up to this are other unrelated cases just have the same investigators are going to be looked at a lot closer. It's going to be a lot of appeals.
Yeah.
All right.
We all know that Brian Walsh already did send an appeal. Well, he wanted to, but I don't know. He wanted for charges to go away because of Michael Proctor, something like that. So yeah, we'll see how that will go.
We'll see. He jumped the gun a little bit. He needs to wait it out. All right. Thank you very much, Angela. I appreciate it. We're going to probably do some court hopping here in just a minute. So thank you.
Yes, I'll rejoin the chat now.
All right. We'll see
Bye-bye.
Bye.
Bye-bye.
Apparently, it's Happy Canada Day to all of the Canadians, our good friends up north. Happy Canada Day. I'm sorry I missed that. If the jury hangs, do you think the federal investigation will hinder a trial? Only if they come back with a ruling with some findings here quickly. Last Poet, welcome to the gallery. Good to have you back. Becky Ort, also welcome to the gallery. Good to have both of you in green again. It's wonderful. Thank you for your continued support. Does anyone know how the jury showed up today? I have not heard yet. I haven't seen anything on the social media as well about how they appeared. Lally misrepresented the Sally Port video. There were lots of things that were done wrong, but I think there's a lot of things you can get away with that don't meet the standard to be charged for a crime, especially in a courtroom. All right, I apologize. I know a couple people have asked for a verdict clock on the OnlyFans. I do not have a clock going. I don't even know how many hours in we are. I think it was, but at one point on Friday it was 16-something hours. Not sure where they are today. See the Canadian flags all over the place. Oh, Canada, my home and native land. Yeah, I used to actually sing that song, Oh, Canada, the national anthem, at Scottish festivals. My family does that. DMB Secondus, 1.5 solar revolutions. Time flies. Congratulations on the 18 months, DMB. Good to have you here as well. They have a beautiful song. They do. It's hour 22. Oh, man. 22 hours of verdict. Jury deliberation. Jury clock equals too dang long. Tell you what to do. Let's pop into another court really quickly and see if we can... see what's happening here. Why is that not taking? 2, 3, 4.
About me getting a fountain beverage, which was free, but I didn't understand that you had to be on shift in order to have this privilege of a fountain beverage. I got it after my shift, like an hour after my shift, and then that's why I was terminated. And
Mr. Simon, let me ask you something real quick.
Yes, sir.
Just as it relates to count 5. It says that this occurred at the American Legion. So regardless of why this might have occurred in your mind, did you in fact try to enter into the American Legion at 1320 West Washington in Greenville?
That is correct. Yes, I did.
And was it your intent in trying to do that to commit some kind of larceny therein as a result of all those issues that you were just telling me about?
Yes, to eat food, and yes.
Okay. And then at some point, did you have an encounter after you were attempting to get into that building, or even after you were in it, with the police officer, specifically Trooper Carlson? Did you have an encounter with them?
Yes, I did.
At some point in that encounter, did they give you a lawful command that you either refused or obstructed or opposed them in the performance of their duties?
He asked me to stop and lay on the ground. I just surrendered with my hands up. So yes.
Okay, I didn't catch that.
I think he said they told him to lay down on the ground, and he didn't do that. But he did to surrender with his hands.
He gave up, but he didn't follow the entire command.
All right, so you didn't listen to their commands first when they told you to get down on the ground, but at some point you did?
No, I had already surrendered. I just had my hands up instead of laying on the ground.
Okay, were they giving you commands about to put your hands behind your back or something of that nature, and that didn't occur right when they gave it to you?
The specific words were lay on the ground with your hands behind your back. I turned around with my hands up in the air still. So yes.
Okay. Then I'll ask Mr. Plea, find a factual basis for 2 and 5.
I think that's enough. Yes.
All right, and then Mr. Peterson.
Yes, I'm satisfied, Your Honor.
Court can't take a factual basis for 2 and 5 based on what's been recited here. Mr. Simon, I'm back to you again. Other than what we've talked about here this morning, sir, has anyone else promised you or threatened you or done anything else to you to get you to enter this plea?
No, he did not.
Other than what's been placed on the record this morning, has anyone besides your attorney, because that's his role, is to kind of tell you what we can expect or you could expect and what his thoughts are about what a sentence might be, but has anyone besides Mr. Peterson said anything to you about what your sentence will be as a result of entering these pleas?
No one but Mr. Peterson, no.
Okay.
No one.
Mr. Blade, you aware of any other promises such or inducements to Mr. Simon?
No, Judge.
Mr. Peterson?
No, Judge.
Mr. Blade's court complied with the court rule for taking these pleas?
It has.
How about you, Mr. Peterson?
Yes, Your Honor.
All right. Mr. Simon, now that we've almost completed this process, do you have any questions about anything?
I just want to understand and affirm what the sentencing is as far as the 7-1 cap. Is it I'm here under right now 53 days as of now from May 7th to today, July 1st, and the 7-month cap. I just wanted to understand completely how much jail time I had after sentencing.
So your agreement is for a cap at 7 months. So it will be no worse than that. You'll get credit for the days that you're there if you've got 51 in, if that's what I'm hearing. And then prior to sentencing, you'll have more days in, so you'll get credit for those. Obviously, Mr. Peterson is free to argue on your behalf for something less than 7 months, but it'll be no worse than 7 months, and you could withdraw your plea then if it was. Okay?
Yes, Your Honor.
All right. So any other questions?
Nope, I accept the plea, and I'm sorry for this infraction of my behavior, and I promise I won't be back in your courtroom in the court of magistrate. No, I won't.
All right, so that's the last question that I have for you. Do you want the court to accept your pleas to counts 2 and 5?
I would greatly appreciate if the court did. Yes, sir.
I will accept your pleas. You did offer them freely, accurately, and voluntarily. All right, is there anything else before I conclude it?
No, Judge.
If he is accepted into adult recovery court, would he be sentenced by Judge Krieger, or would he be sentenced here?
No, I would generally transfer the case to Judge Krieger.
Okay, that's what I told.
And let's double check that. So, Mr. Simon, if you do get into drug court, do you have any objection? Does that change anything for you about wanting to go forward with a plea? I will not be the sentencing judge then. You'll be sent to Judge Krieger, and then she'll sentence you and place you in that court if you're admitted to it. Is that all right?
I understand the terms and conditions, and I accept the terms and conditions.
All right, so Mr. Simon, we're all done today. Somebody from probation will be over to begin that process of completing a pre-sentence report and exploring whether you can get into the drug court or not. That whole process before you get back for sentencing takes about 4 weeks, all right? So sometime in the next 4 weeks, we'll get you back for sentencing either with me or with Judge Krieger for the adult recovery court, okay?
Thank you, Mark, court magistrate. I appreciate it.
All right, thank you. You're all set.
Very respectful gentleman there. Just entered a place of establishment where he worked, got some free food wasn't entitled to, and is serving, 7 months time for it? Seems a bit heavy-handed, but there might be more to the story there. We've got one more defendant waiting here. I've never watched this court before. As a matter of fact, I can't even remember where he's from. This is Montcalm County Jail. What state is this?
Okay. Okay. All right.
Can't tell from the flag.
Nice to meet you.
All right, so yeah, 10 o'clock, right?
So we have 2 arraignments for you.
Yep, I got them right here. So who do we have at the Ayden County Jail? With Robert Cook. I didn't catch the last name. Robert what?
Cook. C-O-O-K.
All right. So
Attorney's packed his bags and he's out of here.
Stacy White. I seem to have everything.
That's my granddaughter. He brought his granddaughter to court. Hey, you want to watch me work?
All right. So, Mr. Cook, you're here today for unpaid fines, costs, and other monetary obligations. If that's true, you can be in contempt of court. Contempt of court is punishable by up to 93 days in jail. Do you understand why you're here and the maximum sentence, Mr. Cook?
I am, Your Honor.
All right. You have 2 options this morning. Option 1 is you can enter a not guilty plea. If you want to do that, I'll set this for a hearing. All right. The sole purpose of the hearing will be to determine whether you have, in fact, made the payments as previously ordered. Not why you didn't, just were they made. Option number 2 is you can enter a guilty plea, tell me what has occurred or why they haven't been paid, and then the court would be free to sentence you as it sees fit. Just to give you a little bit more information, it appears that you have a really obscene amount of restitution due here, $254,000.
Yes, sir.
And
what?
Last payment that we received
254
was back in 2023 for $35. It looks like you paid a grand total of $93.71 on your restitution
out of
since
a quarter
2020.
million.
So that's where you're at.
Yes,
What would
Your
you
Honor.
like to do today, Mr. Cook?
I am guilty, Your Honor. I did set up a payment plan and I missed it. I missed the payment.
Well,
I was
hang on then. Do you want to enter a plea then, and I can take your plea?
Yes, I'm guilty, Your Honor.
All right, if you raise your right hand, I'll have you sworn. Mr. Cook, do you solemnly swear affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You can put your hand down. So much of what I'm going to say to you is a repeat of what we just talked about, so kind of bear with me. Do you understand, Mr. Cook, that you have a right to have a hearing as it relates to the contempt of court? In other words, the allegation is that you haven't paid those monetary obligations as previously ordered. Do you understand that? You have a right to have a hearing?
Yes, Your Honor.
Are you waiving your right to have that hearing, Mr. Cook?
Yeah. Yes, Your Honor.
So waiving your right to have a hearing means that you're then waiving all the rights that would come along with a hearing. I have to describe those for you now, so if you bear with me. That means that you're waiving the right to be presumed innocent of the contempt. That means that you're waiving the right to confront any witnesses that would be called against you, or call your own witnesses. So on a contempt issue like this, I'm sure you get this, but you could call witnesses that would say, hey, I dropped him off on the 1st of every month and watched him walk into the courthouse where he was going to make a payment, right? It means that you're waiving the right to testify at a hearing, or not to say anything, and the court couldn't use that against you. So again, in a hearing of this nature, you could say, yeah, I walked in on the 1st of every month and I made a $400 payment. All right.
Yes, Your Honor.
You're also waiving the right to have the assistance of an attorney. If you'd like to have an attorney, you have a public defender's office, or you could hire your own. Are you waiving all of those rights that would come along with a hearing?
Yes, Your Honor.
All right. Has anybody promised you or threatened you or done anything else to you to get you to contemplate entering a plea to the contempt, Mr. Cook?
No, Your Honor.
All right. And has anybody said anything to you about what your sentence might be as a result of entering a plea to contempt?
They have not, Your Honor.
All right. Then, Mr. Cook, how do you plead to the allegation of contempt? By failing to make those monetary obligations as previously ordered.
Guilty, Your Honor.
All right. What do you want to tell me in addition to what we've already talked about?
Your Honor, it's a lot of money.
Well, I've been out of, I'm on parole. I've been out of the joint for just over a year, since April last year. So that's why those payments haven't been happening since before last year. I did set up a payment plan when I got home. I temporarily was laid off from my work, but I am working now. And I am more than happy to set up another payment plan and get it going. I have.
Where do you work?
It's called the Loan and Liquidation Station in Rockford, sir, Your Honor.
So loan liquidation station?
Sounds legit.
Yes, Your Honor.
Is that full time, sir?
Yes, it is.
It's in Rockford. Okay.
Yes.
What kind of work are you doing there?
I do a little bit of everything, Your Honor. I do a little bit of sales. I clean. I do maintenance on the building. I'm
sales
my boss
maintenance.
is yeah, Your Honor.
Okay. Do you have a current address that you can be reached at, or where you're living at? What's the address?
1024 Cross.
We're going to turn off his address. We don't want that.
1049. Apartment 2.
All right. Is that a placement that DOC obtained for you, or is that just a friend, family, or your own place?
That's a family friend, yes, Your Honor. That is
okay.
DOC.
And that's where you think you'll be living for the foreseeable future?
Yes, I know I will be there.
Okay. How about a phone number that you can be reached at?
61
867-5309.
Since my phone is currently off, but I will gladly provide a number when I get home.
Okay. And then what do you think you could pay a month if you're released?
Let's do the math on this one.
Currently, I mean, I could probably do 100.
Ooh.
Okay. Do you have any other holds at the jail there?
I do in Mecosta, but they're not going to pick me up. It's for fines from like 15 years ago. They don't want to.
Presume at some point you'll have to make those payments too.
I will take care of it. Yes, I just have to get a hold of those. That's from, I didn't even know about that warrant until a while ago.
Okay.
But
so you think you can do 100 a month?
Yes, Your Honor. I could do it within a week.
He owes 245.
If I could go home today and get back to work, I could do it within a week, the first payment.
Okay. When would you like your payments to be due?
I guess, is that something that I could talk about to the lady? I forgot her name. I did talk to her one time when I got home, but I'm not quite sure.
But let me ask you this, sir. One of the easiest ways to do this, if you don't think you're going to be switching employment anytime soon, is you could just do a wage assignment. So we can take your employer's information, and they can just take it out of your check, $50 a check or $25, whatever it might be.
I would be fine with that, but he does pay me cash under the table at the moment.
Well, that makes it a little hard for a wage assignment.
Right. But
do you think at some point you'll be
right to the
Fed? Do you think at some point you'll have a W-2?
Yes, I will.
Oh
Your
my
Honor.
goodness.
He is working on getting all that taken care of.
All right. So why don't we do this? Today is the 1st.
So the Loan Liquidation Center.
First payment of $100
might be visited by the
July
IRS.
15th.
Okay. That is absolutely doable.
And then after that, we'll make the payments due on the 15th of each month, on or before, all right?
Okay.
Of $100 a month.
Yes, Your Honor.
Boss is going to be so mad.
I've been trying very hard since I've been home. I've been doing great on parole, and I'm trying to get by, and I temporarily lost my job for a little bit, and I should have notified her, and I messed up, and I'm trying to get done and get off.
All right. So how long have you been in the jail?
Since Saturday, but I was in Kent County for 45 days.
Okay. Why were you in Kent County for 45 days?
Misdemeanor use.
All right. So is that going to end up with some sort of parole violation?
No, my PO is waiting for me to be done here so I can contact him and get back to my
paying those bills.
I don't have any parole holds or anything.
All right.
Okay, I need
so
to know
here's
why
what we'll
he
do
owes
then,
$250,000.
Mr. Cook. I'm going to sentence you to 3 days in the Union County Jail with credit for 3 that you've served. First payment must be paid on or before July 15th, and then thereafter $100 on or about the 15th of each month, on or before, I should say. All right. And then I just noted here that you can contact our collections department at any time to set up a wage assignment once you're actually on the books, so to speak, being paid, where it can come right out of your check. I can't tell you that's, especially with this sort of restitution that you have in front of you, by far the most easy and consistent manner to keep yourself out of problems. When you just have a little bit come out of each check, you don't worry about it. It's been taken care of. Now, if you do end up with a W-2 here at some point and you're making some more money, you can always check to collections to increase the amount you're paying a month. If you have extra, you can always pay extra. But for now, we'll keep it at 100. Just keep them in the back of your mind with a restitution amount of this nature. At some point, you'll probably be off parole before this is paid, but this doesn't go away. All right.
Nope.
So there'll still be this collections contempt issue out there. So make sure you stay on top of it, even if you do get discharged from parole at some point.
Absolutely, Your Honor. I do want to take care of it.
All right. So you do have a right to seek appellate review of the sentence. And if you'd like to do that, you have 21 days from today's date to make that request. And if you want a court-appointed attorney to assist you, you have a broader window of 42. So 21 and 42. You are all set today, Mr. Cook. Make sure once you're out and about, make sure you just check in with collections. Don't forget about that payment on the 15th, all right?
Absolutely. Thank you, Your Honor.
He's going to pay his first $100.
And then who's the next one we have there?
Stacy White.
All right.
He's going to pay his first $100 towards
Briefly,
that
Ron?
$250,000. This is my granddaughter.
That's my granddaughter, Adana.
Adana?
Adana Nadi.
Nice to meet you. How old are you? 8.
Let's bring a kid to court day.
You are very tall for 8. Are you tallest in your class? Pretty much. Yeah. Where do you go to school? No, where's that?
Wolverine Lake.
What city?
Wolverine Lake, down by Novi.
Oh, down by Novi. All right.
Her dad's a doctor of physical therapy down there because of practice.
Oh,
Looks like
so
we
you
woke
hanging out
somebody up
with,
to come to court here this morning.
That sounds so old, Kurt.
Hello, ma'am.
Wow.
Because I am.
Huh.
Big yawn,
So
big
has it been a
stretch.
good day, or is this kind of boring in here?
I don't know.
It's okay.
I don't know how he owes that much.
We're riding the circuit today, so.
All right.
We're headed down.
So 8 might be a little old for this, but would you like to just bang the gavel for the heck of it? You can just smack that real hard. How's that?
So, do you want to play with the gavel? Everyone likes to play with the gavel. It's the only toy he has.
Right.
He's got one toy.
Nice to meet you. Have fun with Grandpa today.
I want you to meet Mrs. Linder. She's the court reporter. She has to keep track of what everybody says in here.
Nice to meet you.
Judge is like, okay, we've got people literally waiting. I know you can't see them. Mr.
We'll get
Defense
that in the
Attorney.
official records. You bang the gavel.
Yeah,
How's
all
that?
right.
Nice to meet you,
Thank you.
Donna.
All right. Are you Stacy Marie White?
Yes, sir.
Hey, Stacy.
All right, Ms. White, you're here today. It's alleged you have violated the terms of your supervision in the following manner. Count 1 says on or about June 28th, that you used a controlled substance contrary to the terms of your supervision, specifically methamphetamine. Count 2 says that on or about June 28th, that you used another controlled substance, buprenorphine, also contrary to the terms of your supervision. If those allegations are proven or you otherwise admit the same, you could be resentenced on the underlying charge of resisting obstructing a police officer, which has a maximum penalty of 2 years. So, Miss White, do you understand that the maximum penalty is up to 2 years?
Yes.
And do you also understand the nature of those 2 allegations that I just read to you?
Yes.
Okay. And now I also have another report here. Let me see if these are the same or something different. Nope, they look like they're the same. All right, so I think we're good. So, Mr. Downs, I assume you're here on behalf of Ms. White, is that right?
It is correct, Your Honor.
Okay, then your client's wishes.
Is to enter a not guilty plea and set the matter for hearing before Judge Krieger.
Okay. Would you like a status conference first or just go right to a hearing?
No, status conference would be perfect.
Okay, so it looks like Judge Krieger's next docket day, today is the 1st. So I think she's in on the 9th. I'll schedule this for the 9th of July. 9th
Your
of
Honor.
July. Yeah.
I had scheduled a hearing, an ARC hearing, that she is a new member of ARC. She's an ARC participant. And I had scheduled a hearing before the ARC team for this Wednesday, the 3rd. Would a status conference be necessary before we go to that? Or
no, the sooner the better. So the 3rd would be perfect. What time, Jason?
9 a.m.
it says.
First name basis, Jason, huh?
So I'll say we'll schedule it then for that July 3rd, 2024, 9 a.m. hearing with Adult Recovery Court. And then the only thing we need to do is address this issue of bond. Agent Spear, I do have in front of me the request in summons. I'm going to sign and date that, but do you have a position as it relates to bond?
Yes, Your Honor. And thank you for that. I used a detainer, an MDOC detainer, so we didn't use a bench warrant. But as for bond, I would recommend no bond, just because she is a danger to herself using methamphetamines again for the second time in less than a month. And she's on a previous probation that has absconded and cut her tether.
Yeah. So she's
Hey, Mr. Downs, what's your thoughts?
She's just tired.
Well, I know she's really was only released from jail for a week. She was had started the adult recovery court, was released on tether the week prior, I think on the 21st. But certainly leave it to the court's discretion whether there's a bond or no bond between now and Wednesday at the hearing.
Is anyone aware of the absconding with cutting the tether? Did that, or is that going to relate or result, I should say, in some sort of charges?
No, Your Honor, she's serving currently for the use of, assault resisting obstructing, but there was no new charges for the tether.
Oh,
lucky.
Okay.
And it was
usually
over, I believe it
they
over
can
a year
charge you
ago.
for damaging.
Okay. So it's somewhat fortuitous. It's that absconding with the cutting the tether did result in a new felony charge.
I don't have
All right.
details of that.
I'll adopt the recommendation. The purpose of bond is twofold. It's to protect the public and to ensure the appearance of the defendant. Now, the current allegations certainly go right to the heart of both of those. If it's as alleged that the probationer is involved in the use of substances, 2 different controlled substances, that would reflect on whether it is likely she appears for court. It also would reflect on safety of the community if we're talking about controlled substances and those being used outside any valid
Aaron has
monitoring
joined us.
system.
Welcome, Aaron.
And then also, court can consider history. Just with this charge, apparently the defendant has a history of absconding and even cutting off a tether. So she's demonstrated in the past that her likelihood of appearing is not very great. And that also then endangers the community. So for now, bond will be revoked. Certainly she can raise that issue again at her hearing on the 3rd with the adult recovery court. Maybe they'll do something different. Maybe they'll do something in the alternative. Maybe it'll just remain revoked. I don't know, but that's certainly something that can be discussed at a later date and time. All right, anything else from either side?
Oh, Your Honor, thank you.
Okay, and I think that completes everything we have at the IME jail. Is that right?
Yes, sir.
Okay, thank you.
Thank you.
We do have.
Then
we've got one more.
So 10 o'clock. Is it 10 o'clock? Almost. Like
one more court.
Sealy and Sealy. Do we have anybody?
Judge
on
Wolf also is live here, or about to be. So
maybe not. Okay.
Yes.
So your
I'm
name?
here.
I'm here.
Okay. What's your name?
Aaron Seeley.
Okay, and then who else do we have?
My name is Moran Nguyen. I'm appearing for Jody Jernigan.
I didn't catch your last name.
Nguyen.
Win?
Yes.
All right, so I don't have Miss Gallagher, but I did see her earlier. So what we'll do is go off the record here a minute, see if she comes in. I noted it was 1 minute before 10. We'll be back in just a couple minutes, all right?
Okay, thank you.
And then who do we have at the Montcalm jail?
Sure.
Who do we have at the
Daniel
Montcalm County jail?
Alberta.
What's the name?
Daniel Alberta.
All right, we can do that. So, Mr. Alberta, you're here today for failing to pay fines, costs, and other monetary obligations. So you've been on long enough. You might have heard me go through this with another guy before, Miss White.
Yeah, sure.
All right, so you have the same options here, sir. You can enter a not guilty plea if you want to do that. I'll give you a date where you can have a hearing. The sole purpose of the hearing will be to determine whether you made the payments, not why you didn't. The contempt is punishable by up to 93 days in jail. Option number 2 is you can enter a guilty plea, let the court know why you didn't make those payments, and then I'd be free to sentence you as I see fit. Just to give you some more information, it looks like your total is a lot less than $250,000. It's $1,857.60.
Look at the bright side.
And it looks like the last payment we received from you was February 12th of 2020. So, Mr. Cook, do you know what you'd like to do today, sir?
What are my options?
You know what you'd like to do today? I'm sorry, not Mr. Alberta.
I'd like to enter a guilty plea.
All right, then I'll have you sworn. Would you raise your right hand? Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can put your hand down. I've got to cover all that again now that you've been sworn, so it's going to sound like a repeat for some of this. Again, Mr. Alberta, you understand you have a right to have a hearing. Are you waiving your right to have the hearing?
Yeah.
And when waiving your right to have the hearing, you waive all the rights that come along with a hearing. Those are as follows. You'd have the right to be presumed innocent of the contempt. You'd have the right to confront any witnesses called against you or to call your own witnesses. You would have the right to testify at a hearing of that nature or not to say anything. You'd also have the right to the assistance of an attorney. So are you waiving all those rights that would come along with the hearing?
Yeah.
All right, Mr. Alberta, has anybody promised you or threatened you or done anything else to you to get you to enter this plea?
No, they did not.
Okay, and then has anybody said anything to you about what your sentence might be as a result of entering a plea?
No.
All right. Then how do you plead to contempt? By failing to make the payments as previously ordered.
Guilty.
All right, Mr. Alberta, what do you want to tell me about this? It looks like, as I mentioned, the last payment was received way back in 2020.
I didn't have the money. I'm on SSI. So I didn't have the money at the time, but if you did let me go today, I do have the money saved up to pay.
Pay the whole balance, $1,857.60.
Yes, I do got the money to pay it now.
Well, let's start with this. Do you have other holds at the jail?
Excuse me?
Do you have other holds at the jail there?
No, I do not.
How long have you been in the jail?
Since Saturday.
So you got 3 days there?
Yep.
Do you have an address that you can be, or where that you're living now, sir?
Yes, I do.
Where do you live?
3360 Cody Lake Road, Coral, Michigan, 322.
Sorry about that. We're trying to do a million things at the same time.
So that's Coral, Michigan?
We've got a few courts happening.
How about a phone number?
It's
616
867-5309.
096.
Looks like Judge
So
Wolf is in.
616-322-6096.
We're gonna jump to Judge Wolf right now and see what he's got going on.
Okay.
That is my fiance's phone.
Let's see. Judge Wolf is on 7.
Yup.
Let's see. Judge Wolf is 7.
So, Mr. Alberta, you believe entire balance?
Why do I have him coming through on 7? 2 and 3.
Balance is $1,857 and 60 cents. Half.
Weird. I've got some weird stuff going on here. Hang on just 1 second. Let's go back to 3 for a minute.
I can pay it every month.
On behalf of Eric's
Do you work?
Realty.
No, I do not.
Continue.
Well, how are you going to make the payments? So, unfortunately, sir, I don't have the file in front of me to see if we've been through this exercise before. I do know that if we last saw you in 2020, somehow you've avoided this. Doesn't look like we had a previous payment plan. So you said you had a fiance?
Yes.
There we go. I had double
Did
audio.
she bring that money down to get you out?
No, because my dad is my payee, so I'd have to be released and then go get it and then bring it back to the court.
Okay.
Judge, if you let me
this
go,
could be your lucky
I'll pay
day. Mr. Alberta, I don't have that file in front of me. So what I'm going to do, I'm going to take you up on your offer, but I'm going to make a big note with a giant star that says, Mr. Alberta is going to make a payment of $930 by 4 p.m. tomorrow.
Okay.
If you don't, then that's going to be right in front of me next time I see you. And there will be a next time. I know it's been a while, but at some point the warrant will surface and
you will be back.
Most inconvenient time for you, we'll find you. And then we'll be talking about how many days in jail you'll do instead of paying half of it again. Okay?
All right.
All right. So I'm going to give you 3 days in jail with credit for 3 that you've served. I'm going to order that $930 be paid by 4 p.m. tomorrow, which is July 2nd. If you can do it today, that's even better.
All right.
And then thereafter, I'm going to order that you pay, how much a month do you want to pay till it's done?
How much is it?
You'll have a balance of about $930.
Sorry, I don't think he has intent to pay that today.
Oh, could we pay a payment of 200?
200 per month?
Yes.
That's fine. And then 200 per month until paid in full.
Yep.
You want to make that due on the 1st or the 15th?
Let's do it on the 15th.
All right. So I'll say your first monthly payment would come August 15th. Okay.
All right.
Okay, then, Mr. Alberta, you do have a right to seek appellate review of the sentence. If you'd like to do that, you have 21 days from today's date to make that request. And if you want a court-appointed attorney to assist you, you have a broader window of 42. So 21 and 42. You have any questions about anything?
No, sir.
Okay, nobody's going to call you and remind you, okay? So we'll prepare this order, but nobody's going to remind you, hey, that $930 needs to be paid today or at the latest tomorrow. You've got to get that done, okay?
All right.
All right, same with the monthly payment starting August 15th, $200 a month, okay?
Okay, now we fixed all the audio. I think Judge Wolf is doing, I think it's, let's see. Judge Wolf is doing landlord-tenant stuff.
Their responses to the statement of undisputed facts, because I don't think they're accurate.
Let's know.
Yeah. Landlord-tenant's not as exciting.
9-1 Ms. Gallagher, and it looks like maybe her client is present, and then Ms. Wynn is filling in, I suppose, for Mr. Jernigan today, and the defendant also appears remotely. So final settlement conference, I'll start with the plaintiff, Ms. Gallagher, where are we at?
Final settlement conference.
Well, we had mediation, we covered the personal property, which was extensive, and we came to an agreement on that. We have several minor issues. My client would like a digital copy of the family photos. She would like the PIN for the small safe that she got in the personal property settlement. There are 2 checks, a state of Michigan tax refund and an insurance overpayment that are joint. We had hoped to see everybody here today so we could physically get sign-offs, but the insurance overpayment is the bill she paid, and that needs to be signed by Mr. Seeley so she can cast that. It's in both their names. The state of Michigan refund is also in both their names, and she hasn't seen him to have him sign it, and we thought we could address that at court today. They could run to the bank, or he could we could put it on the record so the trustee to go to the bank, sign check and put half in his account. So we have those. There's also an issue where she has been paying for his health insurance and he has been paying for her phone. He wants her to get off his phone plan, which she's fine to do, but her employer won't remove him from the health insurance until divorce is final. We have an order from Your Honor. So those are, I believe, relatively minor issues. The bigger issues of custody, or at least legal custody and parenting time. I think we have an agreement on physical custody because Mr. Sealy has moved to Bay City. So that's what we have left. There's a hearing with friend of the court that was adjourned from May to later in July. And I'm sorry, I'm drawing a blank on the date, but not too far off. Is to deal with custody and parenting time if we don't have an agreement beforehand, but that's
just some minor
all
issues.
that I know.
All right. Well, Ms. Nguyen, I know you're just filling in, but does that sound accurate?
That sounds accurate. It is also my understanding that there was a mediation held on the 19th. There was an evidentiary hearing scheduled for the 24th of July. And because Ms. Jernigan has a conflict today, she requests that the settlement conference be adjourned until after the evidentiary hearing, being that custody is the only remaining issue, Your Honor.
Well, here's what I would be inclined to do about that. It sounds like pretty much everything's been resolved. We just need to get some housekeeping matters done. What I would propose is I don't have any heartburn adjourning this today, but I'm not going to adjourn anything else. I want to keep this moving. And I think if we have to all get dressed up and come back on the 24th, that'll keep some impetus under the parties to work through their attorneys to finish this up. Ms. Gallagher, does that sound plausible to you?
Yeah, I think she has two sizable checks that are joint that need to be dealt with. That's kind of, I think, the one is over $2,000 that she paid a premium for family car insurance.
Well, let me ask Ms. Nguyen.
They're not here.
Ms. Jernigan going to be back in town anytime soon?
She's on a plane and she's supposed to land sometime today, Your Honor. Yes.
Well, I don't necessarily need her presence. What I meant was if she would be available even next week for Ms. Gallagher to contact, and so we can arrange a date and time to get the litigants in the same room to at least get checks signed and move this forward.
She should be in town at the end of the day, Your Honor.
Okay, you mean that she's on her way back?
Well, they sort this out.
Yes, she's on her way back. She just unfortunately wasn't able to get back on time for the 10 o'clock this morning.
This divorce is a little bit messy,
So,
it looks like.
Ms. Gallagher,
While they sort it out, we're going to be jumping over to Judge
Court work is
Simpson
simply,
in just a
hold
moment.
this in abeyance, this final settlement conference. I'll give you the opportunity to work with Ms. Jernigan and see if you can clean up these last few things, and then
Yeah, I think that
do
would
a
be
consent
great. I
decree.
just told my client, bring those checks, we'll all be there and we can sign it.
Sure.
I did not know, so.
Let me ask you this. I want to be an optimist. How would you like to take some proofs? And that way, if you get these cleaned
Sure.
up, nobody has to pay their attorney to come back
Yeah,
again.
I think that's, if counsel doesn't object, I think that makes sense.
All right, well then, Ms. Sealy, if you'd stand and raise your right hand, this clerk's going to have you sworn, and then your attorney's going to ask you a couple of questions.
Do you swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Yes.
All right, you can have a seat. Ms. Gallagher, go ahead.
Thank you. Ms. Sealy, would you state your full name, please?
Penny Sealy?
You can have a seat.
And Penny, you were married to Aaron Sealy?
Yes.
And you filed a divorce in this county more than 6 months ago, is that right?
Yes.
And prior to filing your complaint for divorce, had you lived in Montcalm County for at least 10 days?
Yes.
Had you lived in the state of Michigan for more than 6 months?
These are the requirements for a divorce.
You alleged in your complaint that there'd been a breakdown of your marriage relationship?
Yes.
And that it was to the extent that the objects of matrimony could not be preserved, and you're asking the court to dissolve the marriage by divorce. Is that true then and true now?
Yes.
You and Mr. Sealy had children during your marriage, 3 of whom remain minors. Is that correct?
Yes.
And your 3 minor children are with you and they attend Carson City Schools, is that correct?
Yes.
You and there are no other children born or adopted during your marriage that are minors. You have one adult daughter. Is that
Correct.
true? Both of those things are true?
Correct.
You're not currently pregnant.
No.
And you and Mr. Seeley have essentially worked out a property settlement. You've sold your house. You've come to an agreement on the tangible personal property. There's the issues that I listed as far as you want a digital copy of the digital photo record in his possession from your family photos over many years. You want the pin to the safe that you got left with you in the house, is that right?
Yes.
You want to cash the state of Michigan refund check and divide that. You want him to sign off on an insurance overpayment check so you can reimburse yourself for the overpayment.
Yes.
And you want any pending motions that we had are to be preserved as far as custody or the health insurance and the phone bill. Is other than the things we've mentioned as far as property and financial issues, is there any other issue that you know of that needs to be resolved by the court in this divorce?
No.
Okay. And so custody,
We're going to jump from this one here in just a
child
moment,
support,
since we have something to jump to.
address these more minor issues. Those are the only remaining things. Is that correct from your standpoint?
Yes.
I guess the only other possible thing, you just moved out of the house. There were some things left behind by Mr. Seeley. You believe that he's made some arrangements with the new owner, which is absolutely fine with you, but you just, if anything should come from that, you're gone and out of the house and took everything you were supposed to.
Yes.
Okay. I don't have any other questions. Oh, I guess if we do come up with a settlement and you sign a judgment, do you believe it would be a fair and equitable agreement?
Yes.
I don't really have any questions.
Court is satisfied from the proofs that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There is no reasonable likelihood the marriage could be preserved, and it may be ordered in the judge that the parties be divorced from the bonds of matrimony, and a judgment of divorce may enter in accordance with what has been agreed upon by the parties, along with other standard terms and conditions. So what we'll do is we'll hold this final settlement conference in advance. We'll probably send something out to both parties and get it on in 2 weeks or so, or we'll just keep our scheduled date for the 24th and maybe treat that as a final summer conference too. Then if we
I think that is our hearing with friend of the court.
Oh, it's not here. Okay, then we'll do something here after the 24th. How's that work?
Okay. Yes, we had a hearing date in May and that got bumped. So
okay.
We're now going in June. So it was kind of convoluted.
But I don't want to lead the parties. There's nothing that prevents the court from signing a consent judgment of divorce while you still figure out the FOC issues. All right. There's nothing that this getting you actually divorced should be held up by what's going on down there. But with that, we'll see what happens, right, and we'll go from there. You guys are all set. Thank you.
Thank you.
Yep.
Thank you, Your Honor.
You're welcome. So this is at 10:30. What time? We're ahead of the game, Jan.
We're ahead of the game.
So,
Alaska the Malamute, thank you. Welcome back to the world of green. I appreciate that. AZDCS Oversight gifted a membership as well. That went to Patty Sesser. Congratulations, Patty. Thank you, AZ. All right, they're ahead of the game. So we're going to jump back to Judge Wolf this time with correct audio. See if he has anything interesting going on here. Oops. It'd be better if we do it.
I'm reading this. Ms. Martin, if I'm understanding you correctly, you're right now, the first thing is you're asking to inspect a chart. Is that what the main issue is?
There are two. We are requesting to inspect a chart. When we first began communicating with defense counsel about inspecting the chart, there was no opposition, but we had trouble getting a date out of defense counsel. And of course, this requires a lot of coordination because it's a skilled nursing facility and only certain folks have administrative credentials to the chart to be able to do this type of inspection. So we are merely asking for a date. And then when we filed this motion to compel, defense counsel also in responding to that motion to compel chart inspection requested a protective order. So that's procedurally, that's where we are.
When we've got a second, looks like a filing was made official the end of last week in the Brian Koberger case, scheduling the trial dates, although we know that it's going to be changed. Not necessarily the dates, but the location, because they do have that status or the venue, change of venue hearing, which is going to happen in about almost 2 months. But they do have now an order setting the trial date for 8:30 a.m. on June 2nd, 2025. That's the jury trial commences, and August 29th is when the trial runs. All these numbers are going to change.
Response? Thank you, Your Honor. So I would first like to respond to Ms. Martin's assertion that we've never objected to a chart inspection and that we're just now objecting. But we only objected once a formal request was served. Parties can, and as the court knows, can try to resolve discovery disputes between themselves before involving the court. And once a court...
We're jumping to Cedric.
David I. Goldstein, appearing in place of Jeffrey Bennett, counsel of record. Mr. Bennett is tied up in the court this morning, Your Honor.
Mr. Whitley, you have no objection to that?
No, Your Honor.
Okay, Your Honor, my understanding is that a preliminary examination had been started in this matter. However, after consultation with Mr. Shipley, Mr. Bennett, and Ms. Hughes have agreed to waive the balance of the exam.
Yes, and I don't have a problem doing that. However, and I don't know if you're aware of this, Mr. Goldstein, we ran into a problem.
I understand that, Your Honor, and I was sort of briefed. I wouldn't say I know all the details.
And I'm a little bit, while everybody's here, I'm a touch bit reluctant to waive, knowing that that issue still exists with Mr. Bennett.
Your Honor, my understanding is that Mr. Bennett has hired counsel and that they're in the process of filing a grievance with the AGC. Regarding Mr. Bennett's behavior, if that's what the court's referring to.
Was he the teacher?
That is what I'm referring to. Ms. Hughes, did you have a position on that?
Thank you. Mr. Bennett's staff member is here. She indicated that he has retained Guy Conti and that they will be filing on Friday. That's the update that I have.
On Friday. This Friday.
We watched this before, but I have the memory of a goldfish. What was the case here?
Because, and the reason, Mr. Goldstein, is because that was to be supplied to the prosecutor's office as well as to this court, so that I didn't have to do it.
That's my understanding, Your Honor. Ms. Hughes and I did discuss it briefly before you came out this morning, and she understands the same thing I do, which is that it's being taken care of.
I mean, I understand that's what I'm told.
Yeah, right. Well, that's what I meant. Yeah. All right. Well, knowing Mr. Conti, Your Honor, I think it'll be done.
I think it will. Mr. Whitley?
Yes, Your Honor.
You're waiving your right to a preliminary examination.
Yeah, I'm sorry. At the top of the page, I've got his name wrong. I put Shipley. I'm sorry.
You did.
I was trying to talk. I was trying to listen to you.
And it was my eyes.
Yeah. Sorry.
I will correct that. So really, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed?
Yes, Your Honor.
And you understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right.
Yes, Your Honor. Thank you.
Your Honor, for purposes of the arraignment, my client waives reading of the information, stands mute, asks that a not guilty plea be entered.
Defendant ever waive formal reading, standing mute after being bound over on count 1 with 2 following Court will enter a not guilty plea as to both counts. Pretrial will be set for
August 20th at 1:30 p.m. with Judge Conti.
August 20th, 2024, 1:30. And we'll continue.
I'm starting to hear a little bit about this Sandra Birchmore case.
The people that were demanding a copy of the preliminary exam transcript from last date, since we did technically start it.
Yes.
And I'm requesting that that be filed with the circuit court, the transcript of last hearing.
Yes.
And I do believe, based on Mr. Bennett's staff, that that transcript was already prepared as he requested it as part of his grievance.
Yes. All right. Thank you.
Is that the case with the police officer who's accused of...
Oh, okay. All right. Very good.
It's murder, isn't it?
Thank you so much.
There's some video.
I forgot a pen.
I know, I knew it was a waiver and I didn't bring it.
Really? Really?
All right.
Okay. Thank you, David. No, I'm gonna sit. You just teenage stands adjourned or recess.
They're in recess. Take me out. Take me out. Okay, so who do we have here left? Who's still up? Oh, I've got a couple duplicates. Let's do box 1 is 8, box 2 is 2, box 3 is 3, and box 4 is 7. How about that? Why is that not working? Man, that's frustrating.
The inspection does not occur at all, or that the discovery be had only by a method other than that selected by the parties seeking discovery, which would be deposition, or a more specific set of written discovery. We would also not object to the court issuing a protective order stating that the plaintiff do these things first before going ahead and requesting an inspection.
That's not right.
To Tennessee Rule of Civil Procedure 34.02, any request for inspection shall specify a reasonable time, place, and manner of making the inspection and performing the related acts. The request may specify the form and forms in which electronically stored information is to be produced. The main contention in plaintiff's motion to compel is that Hillcrest refused to provide dates for the inspection to take place, but we're not obligated to do that. This is the rule. It's not discretionary. It's mandatory. Plaintiff responds in her reply that these things become complicated with schedules, but it's really not complicated. She's never given us a date or a couple of dates, a couple of times. She just expects us to basically do the plaintiff's request for inspection for them. We have also been in contact, again, with plaintiff's counsel this entire time, and plaintiff is bringing this to the court without a good faith effort to try to resolve discovery dispute. We're attempting to work with the plaintiff, and yet this court gets involved, which is not in the spirit of the local rules. And so the last thing I would add is that we have already provided the electronic medical record to the plaintiff in written discovery. And so any request for inspection would be cumulative. So not only would it be unduly burdensome and costly and other avenues of discovery are available, but it would also be cumulative. For that reason, the defendants request a protective order, either that discovery not be had or that discovery be done in some way first. And if the plaintiff cannot get the information they are seeking through other avenues, then we could revisit that request. We would also request that if the court does deny the plaintiff's motion to compel, that it also give us reasonable fees for defending this motion.
Ms. Martin, do you have a response?
I do. Your Honor, the reason we have requested a chart inspection is because in discovery, we received the electronic medical record along with some written records, and we, based on our review of those records, do not believe they are complete. That is why we are seeking an inspection. We also requested the audit trail, and defendant objected to that as well. The protocol is, defendant is arguing it's both vague and onerous at the same time, and I do not believe both of those things can be true. It's designed to be specific. It's designed to put the facility on precise notice of what we are seeking, what we intend to look at. And by the way, in defendant's responses to discovery, when it produced the medical chart, it did not represent that it was withholding any documents. It did not include a privilege log of anything it had withheld. So presumably there is no risk of any privileged data being revealed in this inspection whatsoever. And if there were, defendant should have said it was withholding certain privileged information, but it did not.
This is a little boring.
So the
we're gonna
reason we are
again
looking to
Judge
do the
Stephanie
inspection
Boyd.
is because the medical records are incomplete.
So we're going to mute that. We're going to jump to Stephanie Boyd really quickly. Let's see, box source 1 will be 2.
Judge, I have an informal telephone conference with Mr. Tullis and the MAC. I just need a formal writing, but I
will be a
chance to compare my notes from Mr. Tullis with the prosecutors to see if we can fine tune an appropriate plea bargain.
All right, Norma.
Yes, ma'am.
On this one, can you put it for July 30th for plea deadline date?
Yes, ma'am.
We're hopping all over the country
Do you have
trying
any
to find some
questions?
action in some of these smaller
All right,
courts
thank you.
while we wait for the Onlyfans to deliver
All
the
right, you
verdict
too.
or the jury to deliver the verdict, one of the two.
Right up front of your At least it's a short week.
Her purse today looks like is that a Louis Vuitton? No, I have no idea. I don't know my purses. I really don't. You guys, you can tell what it is. Let me know.
Oh, it's too late. Catherine Aguilar. All right, is she in prison or not in prison?
I'm going to say it's Chihuahua, Judge, because I don't know. Last week we contacted TDC because the sheriff's office and said that she had been transferred. And if you recall, Judge, we had a couple of your interns help with that. They didn't have her there at the time.
All right, everyone, please whisper.
I called later in the week. I called back to the sheriff's office to see if they can give me any further details. And I was told that she was transferred to ISF, East ISF.
All right.
I called East ISF and they didn't have a record of her. So I've contacted parole.
All right, who sent her allegedly to ISF?
Well, I think it was part of her parole violation, Judge, whatever she was supposed to do for parole.
Okay.
But parole doesn't even have a record of it, Judge. So that, so I don't know where else to call, Judge.
Oh, well, we're going to find out where she is today. Ms. Abrams?
Yes, Judge.
Is there any way, maybe they didn't want to tell you because sometimes they don't tell people if somebody's there at ISF. Is there any way you can check to see if someone is in ISF?
You guys, we found something we don't normally get to see, and that's a jury
Cost number is
selection.
2024 CR1.
So we're gonna see if we can jump to a jury selection instead. Just 1 minute here. 2 is gonna be 3.
9, 10, and 11 do not apply, and 12, yes, I can.
This is out of Florida. Thanks, Vicky, for this.
Ms. Rose.
My name is Sue Rose. I live in Panama City Beach. I'm retired military. Currently, I'm a part-time cashier at Winn-Dixie. I'm divorced. I have no children.
Jury's doing introductions, so this will be fun. We've never seen this
I
before.
had jury service. It was criminal in another state. I have no lawsuits pending, don't know anyone here, no experience, state attorney's office, and number 12 is yes.
Thank you. Wise.
Yes, my name's Kevin Wise. I live in Bayou George. I'm unemployed right now, but I'm unemployed but I'm retired. I was previously in the Air Force. I'm divorced. I have 2 adult boys, one employed and one not. I have never had no jury service before.
The last trial we watched in this court was a pro se defendant that beat a drug charge where he had cocaine in his pocket.
I've had no experience with the state attorney's office, and I can be fair and impartial.
Thank you, sir. Mr. Sewell.
My name is Blake Sewell. I live in Panama City. No job, not married, no children, no prior jury service.
I think this is Brandy Churchwell's part of the country.
12 yes.
Thank you. Ms. Hussein.
I'm Hannah Hussein, live in Panama City Beach. I'm a server, not married, no children, no prior jury experience or lawsuit. I know Juror 11, 11 Songbird, and yes, I can.
I know Juror 11.
Thank you. Let's see, Ms. Peters.
Angela Peters, live in Panama City, Florida, work at Training Technology, widowed, have 3 children. Works at Skinner's, one at the park doctor.
They've each got a questionnaire. They're answering the form introduction. After that, there will be a voir dire where the judge is going to ask some questions, and then each of the attorneys get to ask them questions.
Thank you. Let's see, Ms. Shepard.
My name is Laura Shepard. I live in Panama City. My occupation is a supervisor civilian with the U.S. Navy. I am married. My spouse's occupation is an attorney with the U.S. Navy civilian. No children. Number 7, not apply. I have served on the jury in a criminal case before. Number 8. Number 9, 10, 11 do not apply. And number 12, yes.
Thank you. Ms. Fields.
I'm Tanya Fields. I live in Panama City Beach. I'm a teacher. I am married. My husband is also a teacher. We have 3 children. One is a boat captain, one is a mechanic, and the other one is a stay-at-home mom. No prior jury service. 9, 10, 11, no. 12, yes.
Thank you. Ms. Rooks.
My name is Brenda Rooks. I live in Panama City. I'm retired. I've been married 48 years. My husband works for Freedom Transport. I have 2 children. One works for Bay Radiology Billing. The other one works for logistics in Washington State. 8, 9, 10, 11, no, and 12, yes.
Thank you. Ms. DeStefano.
Sharon DeStefano. I live in Parker. I'm retired. I'm divorced. I've got 4 children. 2 of them are working. One is in electric and one is a horse trainer. No prior jury service. No lawsuits pending. I don't know anyone here. I don't have any experience that would influence my decision. And yes on number 12.
Thank you. Mr. Butcher.
Yeah, my name is Daniel Butcher. Bay County, Panama City. I was a former lead support specialist, I guess. I'm not married, so I don't have a spouse, no children. No prior jury. No pending, or so that doesn't apply, I guess. Number 10, I don't know anyone.
I don't know anyone.
Number 11.
This is jury selection for a trial that's probably going to begin immediately after jury selection. Like today. Might be a one-day trial. The defendant's over there on the far right-hand side of the table on the bottom, just above the fan.
Wait a minute. No, I don't. I would say that no experience. And then number 12, I would say yes.
Okay, thank you, sir. Mrs. L?
I think 12 is going to be very impartial.
I live in Southport. I'm a surgical assistant for a vascular surgeon. I'm engaged. He's in sales. I have one child and he does not work. He's young. I've never done jury duty before. 9, 10, and 11 are no, and 12 is yes.
Thank you.
The black
Smith.
cardigan.
Yeah, my name is James Smith, by George. I'm a security officer, not married, no children. I've done jury duty before, criminal. No to all 3, 9, 10, and 11, and then 12, yeah.
Thank you. Mr. Sullivan, whenever you're ready.
Thank you, Your Honor. Morning, ladies and gentlemen. As the judge said, my name is Frank Sullivan. I represent the people of the state of Florida. I've got a few questions that I want to follow up with some of your answers, and then I've got a few questions of my own. I don't expect it to take very long this morning. I want to start, Mr. Pierce. When you got to question 12, where you could be fair and impartial in this case, you asked if this case dealt with meth. Did that specific answer that it does deal with meth impact how you answered that question? Okay, so we'll get into that. So in a few moments, we'll talk about the charges. I have to prove that the defendant possessed the substance. That's what this trial is really about. The fact that we're talking about methamphetamine specifically, does that affect your ability to keep an open mind as to whether he possessed that methamphetamine or not? Yes, it does.
Okay.
If you're caught up in that and you're running with the wrong people stuff.
Okay. You understand that I have to prove that the defendant actually was involved in this.
He wouldn't be here if he didn't.
He wouldn't be here if he didn't. Boom. Yeah, he's out.
Mr. Bergen, did I pronounce that correctly? Bergen. Okay. Obviously, you know Mr. Hussein. Mr. Hussein, you know Mr. Bergen.
We'll take the jury question live.
Whether you know another juror is because let's say you both get chosen for this jury and you go back to the jury room and you guys disagree on what the verdict should be. One says guilty, one says not guilty. Is your guys' relationship going to affect your ability to stick to what you believe?
Yeah, I mean, potentially.
So I kind of, she kind of nodded like it's not going to affect her. Not to get you in trouble in a relationship, but are you going to feel like you have to agree with her, or is it going to cause problems in the relationship?
I would say it wouldn't. It would definitely be maybe slightly.
Okay.
To be honest.
No, and I appreciate your honesty.
I don't think it would be fully as if maybe she wasn't here. You know what I mean?
But it's something that you would potentially take into consideration. Mr. Sam, what about you?
Probably not.
Okay. You have no problem sticking your own ground?
Yeah,
telling
but
him
I
he's wrong?
might bias him. I'm not sure.
Okay. I appreciate your honesty. Thank you. So I want to talk a little bit about the charges in this case. We're talking trafficking of methamphetamine, and as the judge told you, we're talking over 200 grams. So who thinks, let's start, Mr. Giles, what do you think it means to traffic in methamphetamine?
We're seeing there's a little movement in the Karen Reed case. I'll jump to it as soon as we have audio. Audio's turned on already. So as soon as we have...
Transporting it?
Yes, to sell it.
As soon as we have any motion, we're jumping to that live.
Did I pronounce that correctly? Yes. What do you think about that?
Saying it's the movement of the drug towards sales.
Mr. Woolard, what do you think?
I would say transportation as well as having it on your property.
Okay.
People are coming in the courtroom in the Karen
Ms.
Reed
Bracken.
case. You can see the movement shaking the camera.
Is there anybody else that has a different idea other than transporting? Is it Rose?
Yes. I have a question.
Yeah.
So first you said possession and now it's trafficking. So is that one and the same?
So that's what I'm getting at here. Okay, so in the state of Florida, trafficking can mean several different things. It can mean transporting, it can mean selling, it can mean manufacturing, it can mean delivering, and it can mean just possessing. In this particular case, we're talking about possession. We may also talk a little bit about some of those other forms, delivery, sale. But in order to prove trafficking, I don't have to prove that he was transporting it across state lines, that he was moving it. I could simply prove that he possessed methamphetamine. What's important for trafficking purposes is how much of the drugs we're talking about, the amount of weight of the drugs. In the state of Florida, for methamphetamine, if you possess, if you sell, if you manufacture, if you deliver, if you transport more than 14 grams of methamphetamine, it qualifies as trafficking. Does everybody understand that? There are different degrees of trafficking, so there's different thresholds, 14, 28, and 200. In this particular case, we're talking about over 200 grams. So that kind of leads into my next question is, what does it mean to possess something? Mr. Wise, what do you think?
Have it on your person or maybe on your property,
okay,
your home.
So on your person is an easy one. Everybody can agree that I possess this pen. It's on my person. It's in my hand. That's pretty simple, right? In the legal realm, we call that actual possession. Actual possession. It's something that's on you or within ready reach of you. Now, Mr. Wise, you said something else there kind of at the end that,
or on your home.
Okay. Obviously, you're here in the courtroom and you're not at home right now, but you have items at your house that you possess.
Yes.
Okay. Those items are not on you. In the legal realm, we call that constructive possession. The two ways you can possess something: it's either on you or it's not. So, how do you prove something that's not on you? How do you prove possession, Ms. Peters? So, if I want to try to prove something that you possess, but it's not physically on you, how would I go about doing that? Okay. Okay. You have 3 children. Do any of them live with you?
Okay, there's a lot of motion going on. We're going to take Karen Reed full so we can watch the fan shake, because this might be the last time we see the fan. It just depends what happens here. What we have going on, I'm recording what's happening and Judge Brantley, I think, 14th Judicial Circuit down in Florida, that jury selection. We can jump back to that if needed. We'll catch up on what we missed. It turns out that the trial is not going to start till tomorrow in that case. It looks like they'll have 2 jury selections today, one for a trial tomorrow, one for a trial on Wednesday out of that court. So that's something we can watch. And their court is one where we do get to see what's happening. It looks like we've got audio now from Massachusetts.
You are unmuted.
And there's the judge.
We're back on the record on the Karen Reed, Your Honor. We've got a question from the jury.
All right. So, Mr. Lally, I'd like to hear from the Commonwealth first about due and thorough deliberations.
I'm sorry, I didn't hear the last one.
I'd like to hear from the Commonwealth first about your view on whether the jury has conducted due and thorough deliberations.
Your Honor, while I understand that they have been at this for a while, I would submit that they have not, and I would ask the court not to make such a finding. Reasons for that, Your Honor, this jury heard, I believe, about 29 days or so of testimony, 657 different exhibits marked as evidence, 74 different witnesses who testified before them. And while I believe they've been out for somewhere in the vicinity of 22 or 23 hours, what I would submit to the court based on all of that, as well as the complexity of the issues presented to them, they really haven't even had 1 hour of deliberation equivalent to 1 day of testimony, to each of the days of testimony that they've heard. So while they have been at it for a while, I would submit that based on the evidence and testimony and witnesses and the complexity of issues in this case, I would submit that they have not done a thorough deliberation up to this point.
He says he wants 29
Giannetti?
hours of deliberation, which is another day.
Our view is that it's time for Tui Rodriguez.
Tui Rodriguez.
They've come back now twice.
That's the Allen charge.
Indicating essentially that they're hopelessly deadlocked. The content of this latest message is that they have been over all the evidence. Previous message said they did an exhaustive review. This time they said that they have fundamental disagreements about what the evidence means, and it's a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encouraged them to go over all the evidence in a very methodical manner. I think all indications are that they've done that, and this is what Tui Rodriguez is for. We asked the court to get it.
Yeah.
While he's sniffing.
All right. I think this has been an extraordinary jury. I've never seen a note like this reporting to be in an impasse. I do find that they're now, with the additional time that they went out without coming back Friday saying that they were deadlocked, is due in thorough deliberation. So I'm going to give Tui Rodriguez. So are they ready to come in, Jody?
Here comes Tui. Okay, so the purpose of this charge is very similar to an Allen charge. This is Massachusetts' version of an Allen charge. The purpose is to shake up the jury, to rattle the cage a
So
little
why
bit.
don't I take a recess?
Take a recess, please.
All right. And then Nancy.
So the judge is going to give this charge. It's their version of the Allen charge. Generally, the way that Massachusetts does this, they recommend that it be given nearly verbatim, although it's not a requirement. That they're encouraged not to stray from the terminology that's in that in the Tui Rodriguez charge. But the judge is basically going to say, look, you need to reconsider. You need to go back. This is really important. You've got a job to do here. We're all counting on you to do your job. Go back there and try again. I will tell you, this jury is going to be frustrated with that, because this jury did that to begin with. They did that to begin with. They started and tore through everything and looked at everything and analyzed. Didn't do the straw poll at the beginning, apparently, is what we heard from Yannetti there. And the jury is like, look, we told you on Friday, we have done everything we can. The fact we are hung. And you said, go back and work more. We did. We put in another, I don't know, six hours of work. We disagree on fundamental things that we will not change on. We disagree on what the evidence means. And so if I say the evidence means this and you say the evidence means the other, we have a position we cannot give up. So the judge is going to go tell him, buckle up, strap in, smack him a little bit, and say, go back and try again. Now, interesting, in Massachusetts, there's no limit to the number of times you can give the Tui charge, but I imagine she's only going to give it once. She's already made the finding that this jury is really, just from the way the note was written, is doing a really, really good job and putting in a lot of effort into getting this done and done right. But so you've got this Tui charge, and if they turn around, I wonder if she's going to give them any sort of hope, because I know as she reads this to them, she's going to see a lot of frustration in their eyes, as they're like, look, we've told you twice, how many times do we need to tell you? But it's possible that they might go back and say, okay, let's try again. And this might be a reset and give us at least another day's worth of deliberations out of this. But it's also very possible that the jury goes back and they say, look, we've looked at this everywhere. We know where we are. We know where each person is, and it can only be sent twice. I didn't think there was a limit in Massachusetts, but I might have read incorrectly. Anyway, the jury could go right back, and it could be minutes. I mean, how long does it take to draft another letter to the bailiff? Judge, we're done. So it could be, after this Tui charge, it could be brief, or it could be another 8 hours. I really don't know. Third time's the charm, or 3 strikes and they're out. Which will it be? Poll? Can the jury say, no, we're done, we have our verdict? Lily, yes, but not in court. They have to go back into the deliberation room and make another note and come back. So it's going to be probably after lunch, because the Tui charge, getting everything together, getting the jury out, getting it read to them, sending them back into it's going to be lunchtime here before you know it. So after lunch probably is a safe bet. Just one more free sandwich, right? Just go for the free lunch and then come back. I will say, I think it's more than just a lone holdout. There's got to be 2 or 3 in the minority. I don't know if a lone holdout could hold out this long without some sort of frustration being expressed in the note to the judge. I mean, it's very possible for a lone holdout to wait forever and to just never budge. But I think there would be some expressed frustration, a little more than what we see. My mom was a lone holdout. Good on her. That is awesome. As long as that's your firmly held conviction, I support that wholeheartedly. Laura, said once the charge given, if they say it, they come back, it's over. That's the way it is with the Allen charge. The Allen charge is basically it's often called the dynamite charge because it's like lighting a stick of dynamite and throwing it in the jury box. It really rattle things up, change things up, and try to loosen the logjam. And at that point, a lot of the states in their Allen charge, it says if they come back again, then default. There's no discussion about it. It's over. It's a mistrial, done. Not so clear in Massachusetts, especially because they're able to give this charge multiple times. I think the judge can see the writing on the wall and on the note in front of her as well that they are done. How does it rattle? Steve, on some states on the Allen charge, it will actually give the jury instructions, specific instructions, where they say, okay, go back, you know your position, stop, argue the points that most favor the other side, or tell everybody the parts that are that weaken your position the most. It requires you to mentally flip to the other side and basically say, switch and debate the other side. Look at it from a different perspective. And that's typically the instruction that's given to do this. They don't just say clear your mind and start over. Nobody can do that, but actually debating the other side and taking turns and listening to everybody is usually what happens. And sometimes it works. Did you read their note out? They didn't. She did not. Wait, she might have read part of it. Tui is very informative. It's like an Allen charge. I believe it will be read. I agree that I think it's more than one holdout. Secret Smiler. I also think one of the things that shows the jury is really doing a good job is that the amount of time that passed between when they first were told to go back and try harder. You haven't spent enough time thinking about this till now. This was not just a rush to judgment. They did go back and, they're not just staring at each other, twiddling their thumbs. Do I think the defense did too much by focusing on the Alberts and McCabe's? Should they have just focused on the bad investigation and the police? The defense's job is to introduce doubt. They have no responsibility or obligation to prove anything, but to introduce doubt. And the Alberts and McCabe's were a point of that introduction. Basically, you've got the Alberts, the McCabe's, you have the Proctor, you've got all the Canton Police Department, all those different points. They are points of doubt where you can introduce things where you can start either doubting the testimony or doubting the evidence that's brought in because of them. And I think they did a good job. I can't blame the defense for doing too much when they took just a handful of days compared to the 26 days by the prosecution, where about 3 of them were whether or not it was snowing. So I can't fault the defense on that at all. Will they give the split of a guilty, not guilty? If they do, it's going to be the jury speaking after the fact. They're actually instructed not to tell the judge where they stand or where the vote is at any time. I think the difference might be if you have someone who refuses to deliberate. I think there are methods where the jury could instruct the judge that they have a non-willing participant in the jury, and they can be removed. There have been cases where a juror has been removed and then the jury gets reassembled with an alternate and then continues. Maybe the foreperson who's the holdout. AZ, I would not be surprised if that's true. We know that when the jury first got first came up with a note and said, "Hey, we're stuck." There were two people that were reported from witnesses who were in court that were adamant that they felt they should go back and do more. So they were not on the same page as the foreperson in saying that they were stuck. I don't think they poll the jury, though, unless there's a verdict. If it's just hung, I don't think they poll the jury. It'll be interesting to see what happens here. I'm intrigued. Judge has declared a little break so we can cool down with the fan a little bit. Is there a former Canton police officer in the jury? I don't know the makeup of the jury at all. Even gender. We know that they come from Norfolk County, so that it's possible to have someone from Canton. But they come from all over the county. So you also might have nobody from Canton. You might have a townie on there, you might not. It could be anything. Don't all the jurors have to agree on the note? They all have to agree on a verdict. I don't think they all have to agree on a note. Should have changed venue. Misty, if this ends up in a hung jury and we go to a mistrial, I would be surprised if they don't at least have another motion for or a motion for a change of venue, because specifically with how much coverage this has received, it's been insane up there. On the bright side, we get more fan time. Can anyone send a note? Just the foreperson. Just the foreperson. Yeah, this will be interesting. I'm going to be watching social media specifically of people who are commenting on the reactions of the jurors when they hear this Tui Rodriguez charge. Kristen thanks, says 6 and 6 as far as males and females. Don't know age, don't know locations. I think they would try to re-prosecute. Squidward, I think the actual jury count might be important, and I'm sure somebody's going to talk, and that's something that a juror can reveal without feeling bad about divulging. Most juries won't spill all, just out of respect for the other jurors. They don't want somebody doing that to them. They've had probably some pretty frank conversations in there. They've probably made some friends and shared a little bit. Maybe overshared, you never know, but it looks like we're coming back right now.
Court is in session, please be seated.
All right. So, jurors, I am in receipt of your note. Judge Cannoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds.
Wow.
So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, In order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one, if it makes no impression upon the minds of the other jurors, who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please. All right, so thank you. We'll send you folks back out to deliberate.
All rise for the court, please. Jurors, follow me.
That instruction is so friendly to the defendant. Did you hear how many times it asked people if they were convinced? Check if you feel that they're guilty. If you feel the defendant is guilty, recheck yourself. Look at the fact that you've got all these other people who looked at the same evidence and came to a different conclusion. Are you sure? Are you sure that that's enough? It's extremely friendly for a defense. You are muted.
Goodbye.
The odds of I would be curious to know statistic wise, if a Tui Rodriguez charge is given in Massachusetts and a verdict is reached in other cases, how do they normally reach that verdict? I mean, as far as stats, do they come to not guilty or guilty? Because the way the instruction is read, it's practically begging them for a not guilty. It was wow, much more friendly for the defense than the typical Allen charge, which we've seen. As far as the note that the jury read, this was extremely well written. It was thoughtful. It was deliberative. It was amazing. The judge's like, I've never had a jury like this. Yeah, that part where in the Tui charge where it says that it's not reasonable to assume that there will ever be a jury listening to this case who are better suited and more thoughtful and more reasonable than the 12 of you are. Very, very friendly to the defense. That's pretty interesting. EDB says that most often than not, if the jury is leaning hung, they usually hang. So, wow. They will still come back with a hung jury. Next note, they will say double dare us to go back out. I don't think the judge will. They're all saying they all look frustrated, and juror number 7 seems to be crying. we're seeing some notes. We obviously can't see in the courtroom. There are some people who are live tweeting that. I've seen that from several different places. I'm not sure if it all came from the same source, but we know that at this point in a trial, we've seen that a lot of times the stress on the jury is, is tangible. You can see it. So it would not be surprised at all. One person crying. Does that mean there's one holdout? Or is it just one person just emotionally spent? We know how hard it can be to watch a case in court and just hearing the evidence day after day. It can be emotionally just really hard on you. So with the juror, it might be equally hard. I wish the note had said, "And Your Honor, please don't waste your time giving us the Tui Rodriguez charge." Yeah, that would have meant that we have a lawyer or somebody in the legal profession on the jury, which they might have. Kristen says, "This trial of all those that I've watched has been the most intriguing, hold the most weight. I think this case also speaks to improprieties possible in government." Can you replay the note? I can go back to it here in just a minute. Actually, let's stop this one. Let me grab it from a different feed here. Trying to find the right one. Just 1 second. Give me a second to get to where she's reading the note. Okay. We're going to go back to, this is on a replay. We're going to rewatch it here. Sorry.
All right, let's take a 15-minute break and...
Here we go. It's the jury coming back in. This is a replay from just a moment ago. Listen to this jury note.
All right. So, jurors, I am in receipt of your note. Judge Cannoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one, if it makes no impression upon the minds of the other jurors, who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please. All right, so
that was what we just heard a moment ago. It sounded more balanced that time. The second time through, it sounded more balanced. The first time, it seemed more in favor of the defense. But she does mention that the burden is on the state, and that if there is some sort of doubt out there, she should be found not guilty. I do still think it's friendly to the defense as far as that statement goes, and then maybe that's why Mr. Lally wanted so much more deliberation time before they actually read that verdict or read that instruction to the jury. But it is balanced as far as that goes. But I think there are at least two holding out. Let's see. Caught up on this one. We'll come in on channel 2. Like that picture better. Just look at the evidence and not your own personal feelings. Let's do a quick poll because I'm curious what you guys think on this. Got somebody calling in as well. Just 1 second. They hung up. Sorry. Okay, we have a poll going up right now. The question is, how long until the jury sends another note? Less than 1 hour, 1 to 2 hours, 2 to 4 hours, or how long, or what's for dinner, I think was the option number 4. I think Lally knows they can't afford to do this again. As far as defense, I don't know. I think Lally sees a lot of the writing on the wall as far as what the public perception is, and knows he has to seat another jury from the same public. It's going to be much harder to find an impartial jury that way. You're probably going to end up with people who have heard something about the case but say they can be impartial anyway. Corey, it does definitely encourage people to not necessarily compromise their firmly held beliefs, but critically evaluate their beliefs and make sure that they have the level of belief that they think they did on it, that they feel that strongly about it. Of a trial would be insane. I wonder if it would have the same judge. I wonder if it would all be the same. Can you imagine Lally again proving that it snowed and the apron was cleared? Probably have to have a change of venue. This particular, they're not in Canton. They're in Dedham, right? In Norfolk County. So where would they go? Out of Norfolk County? Into a neighboring county? That would be interesting. I think that would definitely favor Karen if they went out of that county. Say the two suspected lawyers on the jury wrote the note. Here's what I'll say. If they have a lawyer, I'll state this. If they have a lawyer on the jury, they know the process, and they know they're not surprised by them getting the Tui charge. What do you suspect their fundamental differences may be? Whether or not they believe Proctor. If one believes Proctor and the other doesn't, that makes a huge difference in everything else in the case. That would be huge. Mike says it will never be retried. I live here, no chance. Wording in the jury note regarding the state of mind may be indicating jurors are afraid of reactions of community members. Ty from Treehouse Murder, yes, it's being retried. He's got a month or so, maybe 2 months before that happens. Might have a hearing. Did he have a hearing last week? I think there was a hearing last week in the Treehouse Murder trial. Nikki says, it blows my mind that at least one of them believes everything the Commonwealth put forward, including Trooper Paul, over the FBI experts. It's insane. The jury selection we were watching down in Florida before we jumped to this had a gentleman who spoke up and answered a question about the drugs. And he said, yeah, if it's meth, this guy's guilty. Lock him up. And they're like, wait, how can you? He's like, look, he wouldn't be here if he wasn't guilty. Some people may look at that and jump to a conclusion. Some people might say, the cops told us. The evidence is there. They saw it. I believe them. I believe cops. And that could be the basis of all this. Where are people getting the FBI info from? Don't they keep that info close to the chest? Yes, they do. Some of the information from the federal investigation was subpoenaed, I believe. So we have like the federal grand jury information. The transcript was used oftentimes during this court, although they couldn't say exactly what the proceeding was. We heard from that several times. So they know what questions are being asked and who's being interviewed. Brandy says, I cannot wait for them to see when they find out about the FBI and Department of Justice investigation. Some people say those things just to get out of jury duty. It probably works. FBI did a document dump, and they've announced that they have not completed the case. I think they even said that the investigation is ongoing. I'm not from Canton, but I'm in the area. No way this will be tried again.
Call from Angela.
Hey, Angela. Are you
hey.
Are you surprised?
Well, no, I am not. But I was optimistic. I was like, oh, we are going to get the verdict. But no, I was not surprised. It was very formal written. Mm-hmm. You know I have written quite a few formal stuff lately, so I know it was very formally written, not just, it was like all the rumors about who is on the jury might be true, like a lawyer or a police officer.
It definitely didn't sound like they
You
used
know?
ChatGPT to write their note to the judge. I mean, that was well written. But
Yeah. But 8 more weeks of Lally. No, thank you. Okay, and Judge Bev, please, no. I might survive Lally, and it's a huge might. But Judge Bev, no, thank you. Please, no her, not her. We need a different judge. An unbiased judge. She is very biased. Seriously.
maybe
There's so many stuff.
if let's see, they've got 60 days to agree to retry the case, right? But that doesn't mean they start. Does that mean they start the trial within 60 days? Or is that when they say, yes, we're refiling charges, or yes, we're going to retry?
You're asking the wrong person. You're asking the wrong person.
I thought you knew everything. Angela.
I don't know.
No?
Well, not when it comes to that. But I have, I'm just seriously, I have one question, which I did ask in the chat. This year is the election year for president in the U.S. What about Massachusetts? When do they elect the new DA?
Oh, you were breaking up a little bit, but you were asking about when they elect a DA.
Yeah.
It depends on the terms. I think they're in for 2 to 4 years. I don't remember how many. But yeah, the district attorney normally is a political position that you run for.
Yeah, because maybe someone will or can stand up to Morrissey and challenge him, because he has been DA since 2010, if I remember right.
A lot of times it's hard to unseat the incumbent.
What?
A lot of times it's really hard to unseat the incumbent. They have name recognition, and once they're in power, it's easier to stay in power than to take over from somebody else.
Yeah. Well, we'll see. Yep. But yeah, that was the only thing I was going to call. That was the only reason why I called. So we'll see. I hope if they are hung, I hope I hope they don't retry, because this is a joke. Yeah. Seriously, the whole trial is a joke.
If they do retry, I'd like to see them do it differently for sure.
If they do retry, I can't wait to see what new ideas Lally will come up with, how the event happened, and how will he try to fit the Fed's narrative.
If they do retry as well, some of the decisions that were made by the judge sort of get reset, and you go back to the basics again, and you might be able to get different information in, and even the testimony might be different, slightly as you're moving forward as well. It also presents challenges, because if the testimony is different in a major way, now you've got impeachment material that may be available. So,
yeah.
Interesting.
Well, we'll see what's going to happen. Hopefully,
fingers crossed.
Yeah. Okay. See you. Bye.
Bye. Got really choppy there at the end. Sorry about that. Let's see. That was really, really choppy. Alan Charge. We just read that. I missed a comment that I was going to read. Electing a new one doesn't necessarily mean change of policy either. Now, a lot of times you get a hand-picked successor to the first person. No statute of limitations on murder for retrial. I thought they had a time period they had to choose whether or not they're going to retry or not. I guess they could refile new charges, but that's starting at the very beginning again. That's getting a new case number and everything. It was about Aunt Bev. Everyone calls her Aunt Bev. Beverly, the judge. She took a lot of flack. There are people that like making fun of her or imitating her on social media. I also thought that she, for the most part, was fairly fair. that was straight across the board. There have been times where she's expressed some a little bit of feelings that show she might have personal feelings one way or another, but those were outside the presence of the jury for everything that I saw. And I didn't see anything blatant as far as rulings on what was allowed in and what was not allowed in. That just didn't seem like, that she was just trying to throw the case one way or another. I liked her as a judge. Other than I'd like to hear a little bit more about the objections. I didn't like the way she handled that throughout this case. I'd like to hear what the objection was, and maybe even though that gets the jury up and out a lot, I'd like to hear more arguments. When the jury wasn't there, why were we in sidebar? Why can't we have those arguments in open court while the jury's gone? I wish we got to hear that. What did the side counter get up to? I think we stopped counting just under 200, if I remember right. If retried, will Lally ask who, if anyone, was driving the ambulance again? That was a great question, Lally. We're going to end the poll right now. We've got a poll that says, how long until the jury sends another note? We've got 48% come in at 1 to 2 hours, 22% at 2 to 4 hours, only 18% say more than 1 hour, and 10% said, what's for dinner? So, looks like we could expect something here just after lunch, maybe. Maybe just before. The FBI didn't do anything to stop this case from going forward. So I don't think they would stop a retrial from going forward either. They pretty much don't care about what's happening on a local level. They're going to do their own investigation, and then the results of that will impact the court case. Or not. Pat Hall, yes, she did read the Tui charge. We went over the letter the jury wrote, which was remarkable. It was very well written, very thoughtful, very thorough. It's clear that at least the author of the note understood the full impact of what it means if the jury comes back hung. So that was insightful. I think the judge is going to get a copy of that and frame it and hang it on her wall. And she's be like, that's my jury. Yeah, they didn't get a verdict, but look at their letter. That was great. I had an opportunity to retype that, and I didn't. Bummer. Let's see. I think while we wait, we can jump back down to court with. Let's see. Source 2 is 2. 1 is 3. Let's jump down here and swap the boxes around. Looks like they've possibly selected a jury already.
I don't think you have to do that. Just do one. Yeah. Yeah.
We had it set just right.
I know. But I'll walk into it if it's right there. My real name's Grace.
Well, that's good to know.
Seven, member for 18 months. One of the OGs.
Told me that was probably right.
Thanks, Ari. I'm ready for this Karen Reed trial to be over with,
Not
to be
really
honest.
great.
My brain can't do another round of
Let
Lally.
me guess, you're gonna call me Grace here on.
You ready? Are we ready to bring the jurors in? Let's bring them in.
Jurors come in the back door. We get to see them all.
Federal jurors entering.
Let's count them here. 1, 2, 3, 4, 5 guys. Yeah, this is more than this is still the pool.
Everyone can have a seat. Good morning, ladies and gentlemen. Welcome to the Bay County Courthouse. My name is Brantley Clark. I am one of your circuit judges of the 14th Judicial Circuit. Thank you for your service this morning. That's exactly what you're providing, is a service. All of you had different things to do this morning, different places to be. You put all that aside because you got a jury summons in the mail and came down here to make yourselves available for jury service. Our system of justice would come to a grinding halt without citizens such as yourselves doing that. Other than serving in our country's military, I believe this is the highest calling we have for our citizens, is to serve as jurors. I am picking 2 juries today. I've already picked the first one. This is the second one. We're going to try this case on Wednesday. We should have the jury picked by the end of this morning, and we'll come back on Wednesday and try the case. If for some reason you can't spend the rest of the morning with us this morning, or come back on Wednesday and serve as a juror if you got an issue and like to talk to me about it, if you'll bring your jury summons and come up to the bench, we'll discuss that. So if anyone that does not think they can serve the remainder of this morning and come back on Wednesday to serve as a juror, you'll come up.
Bring your excuse.
Right, very good. All right, I am going to ask the clerk, and this is the jury selection process. I'm going to ask the clerk to swear you in. I'm going to give you one instruction, and the clerk is going to call up the first 21 names. If your name is called, if you'll come forward, and Deputy Dexter will tell you where to have a seat. Madam Clerk, if you'll swear the jurors, please.
Would you all raise your right hands, please? You do solemnly swear that you will make truthful answers to all questions which shall be put to you by the court or its authority regarding your competency to serve as a juror, so help you God. Thank you.
Ladies and gentlemen, in order to have a fair and lawful trial, there are rules that all jurors must follow. A basic rule is that jurors must decide the case only on the evidence presented in the courtroom. You must not communicate with anyone, including friends and family members, about this case, the people and places involved, or your jury service. You must not disclose your thoughts about this case or ask for advice on how to decide this case. I want to stress that this rule means you must not use electronic devices or cell phones to communicate about this case, including tweeting, texting, blogging, emailing, posting information on a website or chat room, or any other means at all. Do not send or accept any message to or from anyone about this case or your jury service. In addition, your cell phone or electronic device must be turned completely off while you're in the courtroom. You must not do any research or look up words, names, maps, or anything else that may have anything to do with this case. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're at the courthouse, at home, or anywhere else. All of us are depending on you to follow these rules so there will be a fair and lawful resolution to this case. Unlike questions that you may be allowed to ask in court, which will be answered in court in the presence of the judge and the parties, if you investigate, research, or make inquiries on your own outside of the courtroom, the trial judge has no way to assure they are proper and relevant to the case. The parties likewise have no opportunity to dispute the accuracy of what you find or to provide rebuttal evidence to it. That is contrary to our judicial system, which assures every party the right to ask questions about and rebut the evidence being considered against it and to present argument with respect to that evidence. Non-court inquiries and investigations unfairly and improperly prevent the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. If you become aware of any violation of these instructions or any other instructions I give in this case, you must tell me by giving a note to the bailiff. Madam Clerk, whenever you're ready.
Juror number 105, Wayne Anderson.
If your name is called, if you'll come forward, Deputy Dexter will tell you where to have a seat.
107, Navia Davis.
This is a small trial that's going to happen on Wednesday.
111, Hunter Clapper.
The other jury we were watching previously was for a drug case that's going to happen tomorrow.
Timothy Nelson.
This court shows the jury. That's just how they work. A lot of courts will allow the jury to be shown. There are even some courts
115, Tina Schallenberger.
that will say, to the camera people who are filming court, say, you're fine showing the jury, just don't zoom in close on them.
116, Claudia Estilo.
Other courts say you shouldn't show the jury at all, but that's just the judge's rules, and the judge makes the rules for their courtroom. But generally, juries
119, Jeremy Wood.
Their names are public. You can find out who all of them are. If you go to court, you could watch them. You can see who all of them
120, Walter Hayes. 121, Julia Carbolito.
Bingo.
126, Pamela Burnett. 132, Benjamin Urakins. 139, Anthony Peters. 143, Vonda Hester. 144, Bradley Britton. 145, Jan Otting.
They use almost everybody from this pool.
147, Kushal Patel.
I guess they're just seating them in order so that they know who's who.
152, Stephen Weston.
Just numerical order.
154, Ryan Brotherston. 155, Herman Cash Jr. 157, Melissa Plowick. 161, Kevin Stafford.
'em. I don't think they can. Nova.
Good morning once again. As I said, my name is Brantley Clark, and I'm one of your circuit judges of the 14th Judicial Circuit. This is the second jury I'm picking today. This is a short week, so we're having trials on Tuesday and Wednesday. This is a criminal case. This is the state of Florida versus Gerald Gary. Mr. Gary is to my right with his attorney, Ms. Kim Jewell, the assistant, and Mr. Riley Spence. The assistant state attorney prosecuting the case, Ms. Morgan McAfee.
Good morning.
Mr. Gary has been charged with 2 counts, possession of cocaine and possession of marijuana less than 20 grams. Those charges will be explained to you later on in the process. This is the voir dire or the jury selection process. We all come into this courtroom with different life experiences that makes us better suited for some cases than others. So that's why we go to this process. In just a moment, we'll begin with Mr. Anderson, and we'll ask you, each of you, to answer the questions on the questionnaire. After we finish with Mr. Stafford, the attorneys will have an opportunity to ask you some questions, and then the jury will be selected. If you're asked a question that you don't understand, ask the attorney to rephrase it. If you're asked a question that you don't know the answer to, no is a perfectly permissible answer. If you're asked a question that you do not feel comfortable answering in the presence of the other jurors, ask to come sidebar. It will be with Ms. McAfee, Ms. Jewell, and with Mr. Gary, out of the earshot of the other jurors, but on the record. Regardless of what your answer is, as long as it's the truth, it's the correct answer. That's all we ask you to do, is tell the truth. Now, I know everyone has somewhere else they want to be or need to be this morning. I understand that. You have jobs, children or kids are out of school. This is a holiday week. But it's so important, this what you're doing today. And I'm assuming that all of you feel that way, because I didn't have to go look for it. I didn't have to call you. All we did was send a jury summons out. You got it in your mailbox and you made yourselves available. You came in the old courthouse and looked for a parking space and waited this morning. So I appreciate that. With that being said, Mr. Anderson, if you'll begin and answer the questions on the questionnaire, and then we'll move down the list.
Wayne Eric Anderson, I live in AT&T here. I'm married. Wife works for teachers at kind of thing. I'm married. 2 children. One's she does photography, and my other daughter goes to
I can barely hear him.
No prior jury service. I've been called and not selected several times. No pending lawsuits or anything there. 10. I don't think I know anybody in the courtroom. No experience with the state's attorney or anything like that. And of course, I will be able to be fair and impartial, best that I can see that.
Thank you, sir. Ms. Davis.
My name is Nydia. I live in Panama City. I am a senior manager. I'm single. I don't have a spouse. I have 1 kid. He doesn't work. No past jury service. No pending lawsuits. I don't think I know anybody. No experience with the state attorney's office, and I can be very involved.
Thank you. Mr. Kleckler?
Thank you, Hunter Kleckler. I live in Southport, Florida. Work for Bacon Roads and Bridges. Married. My wife works at the bank. And no credit.
These guys are all quiet.
1 child. He doesn't work. No jury, prior jury service. No pending lawsuits. Don't think I know anybody here. Don't have the experience with the state attorney's office.
Note as well.
Note to 12.
Thank you, sir. Mr. Nelson.
Sir, Timothy Nelson. I live in Callaway. Retired. I'm married, and my wife is also retired. I have 0 children. prior jury service, been 20 years ago or so. No party in pending or past lawsuit. I don't know anybody in the courtroom. No experience with the state attorney's office. And yes, I could be fair and impartial.
Thank you, sir. Ms. Schellenberger.
Tina Schallenberger. I live on Panama City Beach. I work at Gulf Coast Hospital. Divorced. I have 2 adult children. One is recently moved to Indiana, does not have a current occupation, and she's looking for a job. I have a son who's in college and working at shipyard. No prior jury service, no pending or past lawsuits. I don't think I know anyone here. No previous experience with the state attorney's office or anything like that, and I believe I can be fair.
Castillo.
And my name is Claudia.
These jurors are so quiet. There's not a lot to these voir dires. Basically, they'll ask a couple pointed questions about drug users. Are you able to, to hear a case and be fair and impartial? This particular jury is going to come back for a trial on Wednesday. There's another juries that we saw briefly this morning. They'll come back on tomorrow, both for drug offenses.
Thank you. Wood.
Jeremy Wood, live in Southport. I'm a defense contractor. I'm married. My wife is only for 2 children. Do not work. No prior service.
Defense contractor.
That. I know one person in the courtroom, one of the jurors. No experience in state attorney office, agency, and yes.
Thank you. Mr. Hayes.
Knows one of the jurors.
Yes, my name is Walter Hayes. I live in Callaway. I'm a retired Air Force veteran. I'm divorced. I have 4 children. Their occupations, one's underground utilities in Tallahassee. I have a daughter that processes healthcare claims in Tallahassee. I have one daughter that lives in Miami, and she works for the school board. And I also have one son that's in the Department of Corrections.
One son in the Department of Corrections.
Proud jury service. I was called but not selected. Open lawsuits. No one in the courtroom. No experience with the state attorney's office. And I can be fair and impartial.
Thank you, sir. Let's see, Miss, is it Carbolito?
My name is Julia Carbolito. I live in Panama City. I am a senior wage garnishment account manager for ADP. I am married. My husband is an Air Force vet and works for the VES for disabled veterans. We have a son in California. He is a manager at a car insurance company. I have prior jury service criminal. I'm not a party in any pending or past lawsuit, criminal or civil. I don't know anyone in the courtroom. I don't have any experiences with the state attorney's office or law enforcement that may influence any decision. And I can be fair and impartial in a jury case.
Thank you. Ms. Burnett?
My name is Pamela Burnett. I live in Panama City. I'm a workman's comp legal assistant.
I am married. My husband is a real estate agent. We have 7 children between us. I have 4 of my own. My 4 are, one's a supervisor, one's a president of a company, one's a billing agent, and one works for childcare at one of the local churches. I have been on a jury, but it's been 8 or 10 years ago in Georgia. It was not here. I'm not a party to a lawsuit. I don't think I know anyone in the courtroom. I don't have any experience with the attorney's office, and yes, I could be an impartial.
Thank you. Mr. Giardinis.
Yeah, my name is Benjamin Giardinis. I live in Panama City Beach. I'm a tour boat captain over there. I'm single, but I do have a child who's 3 years old, so I'm not working. Never done jury service, first time. I'm not involved in the legal system whatsoever. Don't have any pending or past lawsuits. I don't know anybody here, and I promise to be fair and impartial.
Peters?
My name's Anthony Peters. I live in Baker, Georgia. I'm a tree cutter, divorced. I have 3 children. One's a homemaker, one's also a tree cutter, the other one's a groomer. No prior jury duty, no pending lawsuits or anything. I don't know anybody here. No experience with the state attorney's office. I know I am fair and impartial, I guess.
Ms. Hester?
Yes, Fonda Hester. I live in unincorporated Bay County. I work for Bay County for the Public Works Director. I'm married. My husband is retired military. I have 3 children. One is in sales. The other is a stay-at-home mom. And the other is in the hair industry. Prior jury service, I've never been selected. Not party to any pending or past lawsuit. I do not know anyone in the courtroom. I've had no experience with the state attorney's office, and I can be fair and impartial.
Thank you, ma'am. Mr. Britton?
Yes, sir. My name's Brad Britton. I am in Lynn Haven. My occupation, I'm a service center manager for the Florida Department of Revenue Child Support Program. I am married. My wife is a technical writer for the state of Texas. We have no children. I have no prior jury service. I have no pending or prior lawsuits. I do indirectly know Mr. Spitzer over at the table over there through his parents. I had no experience with the state attorney's office or law enforcement agency that would influence the decision. And I do believe I would be a fair and impartial juror on this case.
Sir.
Yes, sir.
Ms. Ryder?
Yeah, my name is Jan Oddie. Live in Panama City. I have 3 children. They all live in Norway.
Norwegian.
Prior jury service. I'm not pending the past law. Don't know anybody. No experience with the state attorney's office.
This was the judge for the pro se drug. It was another drug charge where the pro se defendant won, beat the charge.
Mr. Patel?
My name is Kushal Patel. I live in Panama City. I work as a patient care technician at Gulf Coast. I'm single. I do not have a spouse. This is my first time being in jury service.
Being single and not having a spouse are very similar.
I don't know. I don't believe I know anybody in this courtroom.
They have a paper they're reading off.
And I've not had experience with any sort of law enforcement, and I can be fair and impartial.
Thank you. Mr. Weston?
My name is Stephen Weston. I live in Youngstown. I'm a welder. I am married. She's a patient care technician at Ascension. I have 1 child in Tennessee. is in shipping. I have no prior jury service, no pending lawsuits. I don't know anyone in the courtroom. No experience with the state's attorney's office, and I can't be a fair and impartial judge.
Mr. Brotherson?
My name is Ryan Brotherston. I live in unincorporated Bay County between Inlet Beach and Panama City Beach. I currently work at Michael's as a customer service representative. I am single. I have no children. This is the first time I've been selected for jury. I'm not party in any lawsuit whatsoever. I don't know anybody in the courtroom right now. My parents were previously employed by the county sheriff's department, but they are both retired, and I will be able to be a fair and impartial juror.
Thank you. Mr. Cash?
Hi, Herman Cash, Panama City Beach. I work for a government contractor. I'm single, no children. I was on a civil case here in Bay County maybe 2-3 years ago. Not currently a party in any pending or past lawsuits. No one, don't know anyone in the courtroom. No experience with the state attorney's office that would influence my decision in the case. And I'm able to be fair and impartial.
Thank you, sir. Howard?
My name is Melissa Plowlick. I live in Panama City, Florida. I'm a human resource manager under Department of Corrections. I am married. He is a local CDL driver. No children. Do have prior jury experience in Collier County and no pending lawsuits. I do not know anyone in the courtroom. My father is also law enforcement in Bay County. I would be able to be there.
Thank you. Mr. Stafford?
Defense is not going to want
This
her
is
on
Kevin
the jury.
Stafford. I live in Parker. I'm retired. I'm single, no children. And called for a jury pool, but never selected. No lawsuits pending. I don't know anyone in the courtroom now, but I did know one that was in the other group. Have any? No experience with that. Yes, I can be fair and impartial.
Thank you, sir. Smack whenever you're ready.
I'd like to make a correction.
Yes, sir.
I just realized I have been involved in a civil lawsuit that had to do with homeowners insurance and work.
Okay.
Slipped my mind.
That's okay. And for the record, that was Mr. Anderson, juror number 105.
That's correct.
Mr. Hayes?
Yes, on 5, I didn't realize it's a former spouse occupation. The Department of Corrections.
Okay. All right, very good. That was Mr. Hayes, juror number 120. All right, thank y'all. Smackty, whenever you're ready.
Good morning, everyone.
Good morning.
My name is Morgan McAfee, and I have the privilege of representing the people of the state of Florida today. How this is going to work a little bit is I'm going to ask you a couple of questions that are kind of follow-ups to the questions that you've already asked. Then I'm going to have a few questions of my own. Hopefully it won't take too long. We can get you out and get some lunch because I know it's getting to be about that time, all right? Is this okay for council? There. All right. There's a few of you guys that said you were retired, and I just missed what you had done prior to that. So I believe Mr. Nelson, you said you were retired?
Yes.
What did you do?
Military, 23 years.
Thank you for your service. I believe Mr. Ayden, you also said you were retired. What did you used to do?
Commercial fishing in Alaska.
I think there's one more. Mr. Stafford, did you say you were retired?
Machinist.
Machinist. Thank you. Mr. Wood, you said you knew another juror in the courtroom. Who is that?
Potential for Mr. Booth right there in the white shirt.
Okay. All right. So the reason that we ask you those questions is if you two ended up being on the same jury, would you be able to stick to your guns if you said guilty and he said not guilty, or would you cave because you have a prior relationship, know each other, things like that? Would you be able to stick to your guns if you ended up on the same jury as?
Absolutely.
Okay. All right. Thank you. Similar question for Mr. Britton.
Yes.
Okay. You said you knew Mr. Spitzer.
Yes.
The fact that he's co-counsel over here, will that affect your decision on anything?
No.
You're able to
just trying to be above board.
Absolutely, absolutely. We appreciate that. There's no wrong answers as long as there's honest answers, right? Mr. Brotherson, you said your parents used to be law enforcement. They're both retired now.
Yes.
The fact that this is a criminal case, I expect you'll hear from law enforcement. Would that affect anything for you? Would you be able to just look at the evidence that is presented in this case and disassociate any experiences you've had with your parents being law enforcement?
Yes, ma'am.
Okay. And a similar question for Ms. Plowick. Would you be able to separate that experience and just look at this case as it's presented to you? All right. So as you may have heard, the defendant in this case has been charged with possession of cocaine and possession of marijuana. And later on in the case, you'll hear what all of those things will mean and what would have to be proven and things like that. But what I kind of want to talk about is crimes in general. All crimes are made up of elements, and then you have to prove each element to make up a certain crime. So I know that that may sound a little convoluted, so I'll break it down a little bit. Let's just say it was illegal to wear a black blazer in a courtroom on a Monday, right? May not be the most exciting of crimes, right?
She's doing it.
But what do you think would have to be proven for that fake crime? Mr. Anderson, what's one thing I would have to prove to show the crime of wearing a black blazer in a courtroom on a Monday?
Probably the black blazer.
Right?
You were in the courtroom, or that it was Monday.
So you have to prove that someone was wearing a black blazer. What else would have to be proven? Miss Davis.
It was Monday.
That it was Monday. All right. And what about Mr. Nelson? What else would have to be proven?
I don't have a good answer for it.
All right. What about Miss Schallenberger?
That they were in the courtroom.
That they were in the courtroom. So I'd have to prove those three things, right? Does that kind of make sense? So what if one of those things couldn't be proven? What if it's we don't prove that it's in the courtroom? No crime. All right. So you understand you have to have all of the elements. Perfect. Now, is everything always black and white, open and shut? You may have more questions about things that have happened, right? For instance, with the black blazer, maybe you see those elements, but
Happy
you
Canada Day,
think,
Ruth.
well, I
Thank you very
wonder,
much.
well, what designer was it? When did they get it? How old is it? Is it wrinkled? You know, those types of questions. Are those things that would have to be proven, Ms. Castillo? Is those things that would have to be proven if they're not part of the elements? You don't think so? All right. What about you, Mr. Wood? Those things, questions you may have that aren't in the elements? All right. Mr. Hayes, would you make me prove more than what's in the elements?
No.
Okay. Even if you have other questions?
No, as long as you satisfy the requirements.
As long as I satisfy the requirements. Ms. Carbolito, did I say that right? Yeah. Okay. What about you? What do you think? Do you have to prove more than what the elements require?
Only what's required by the law.
Okay. Even if you have extra questions?
If we're allowed to ask questions.
Okay. So for instance, going back to my black blazer thing. If it's just the three elements and they're proven, and you may have those extra questions of, well, where'd she get it? How long has she had it? Even if you have those extra questions, does that affect your decision?
No, it would not.
In this particular case, like we said, the defendant has been charged with possession of cocaine and possession of marijuana. And I suspect that the judge at a later time will read to you that the elements that I would have to prove for each of those is that the defendant possessed a substance, and the substance for the possession of cocaine was cocaine. Since these are drug charges, has anyone had any family members that have had problems with substance abuse or anything like that? Can you just raise your hands? Mr. Brotherston? Oh, there's quite a few of you. Okay. I saw Ms. Burnett, your hand. Was it a family member or a friend?
Family member.
Family member. Was what was the substance?
A little bit of everything.
A little bit of everything. Would that experience that you had with that family member affect your ability to be impartial in this case? Okay. Mr. Draken, did I see your hand as well?
Mm-hmm.
Was it family member or friend?
A cousin, family member.
Family member. And what was the substance?
I don't know the exact details.
Okay.
Yeah.
Would that affect your ability to stay fair and impartial in this case?
Not at all.
Okay. I think I saw Mr. Peters as well. Would family member or friend?
Family member and friend.
Okay, yeah. Would that affect, would that past experience with that person affect your ability to be fair and impartial in this case?
No.
Okay. Did I see you, Mrs. Plowick? Okay.
An uncle, but I'm unfamiliar with this.
Would that affect your ability to be fair and impartial? And then I think Mr. Brotherson, did we already talk about that?
Oh, no.
Okay. Would you be able to be fair and impartial in that involving that? Okay. Did I miss anybody? Hands went up quickly. Okay, Mr. Hayes, family member or friend?
Family member.
Okay. Would you be able to put that experience aside and be able to be fair and impartial and judge this case based on the evidence presented?
Right.
Okay. And Ms. Carbolito? With the same question.
Yeah, family, 2 nieces, one on my side of the family, one on my husband's. They live in different states. They don't live near me, but they've both been in rehab for, I believe it was heroin.
Okay. And would that affect your ability to judge this case based on what is presented to you?
No.
Thank you. I know that can be, oh, yes, Ms. Hester?
Yes. Okay. My daughter, as a young woman, a little bit of opioid.
Okay. And would your experience with her influence your ability to be fair and impartial and just judge this case based on the evidence presented?
I don't think so.
Well, thank you. Besides just the substance, we'd also, as the state, have to prove possession, right? What does it mean to possess something? Mr. Draken.
To hold it, to have it.
To have it
on your person.
Have it on your person. What is, does anyone have a different idea of what possession could mean? Yes, Ms. Carbolito.
Witnessing it being thrown away.
Witnessing it being thrown away? Okay. Who has a house? All right, let's go with Mr. Weston. Do you have stuff at your house right now?
Yeah.
Is it your stuff?
It is.
Are you there?
I'm not.
Are you holding it?
I'm not.
Is it still yours?
It is.
Okay, so you still possess it, even though you're not holding it at the moment.
Correct.
Right? Okay, so in the law, that's kind of the idea of actual possession and constructive possession. Actual possession would be like Mr. Draken said, actually holding it. But then there's other ways that you can possess something. What about who drove here today? All right, I'm gonna pick on Mr. Cash. I haven't picked on you yet. All right, you drove here today?
I did.
And you have stuff in your car?
I do.
It's still your stuff?
It's still my stuff.
Even though you're not down there right now?
Yeah, it's still there.
It's still there.
Hopefully it's still there.
Yeah, we're going to be optimistic on it. Hopefully it's still there. All right. Does everyone kind of understand that as to possession? And lastly, the defendant is also charged with possession of marijuana. So just like the count of cocaine, I as the state have to prove that he possessed a substance and that substance was marijuana. Does anyone have an issue or who thinks that marijuana needs to be legal? Okay. All right. Mr. Brotherson.
Couple hands.
I am going to ask you this question. My black blazer, I'm gonna get a tongue twister. This is gonna be a tongue twister. The black blazer hypothetical. Do you think that it would be right for wearing a black blazer in a courtroom on a Monday to be illegal? Is it something you're excited about? Like, yes, we're using resources for this.
To an extent.
Okay.
It depends on the extenuating circumstances, I guess.
Sure.
The manner in which it was worn, or in this case.
Okay. So if it's still illegal, even though you may not be super excited about it, it's not something you want to sit here all day talking about. If it's still illegal, would you be able to follow the law as it's given to you?
Yes.
Is there anyone who has a problem with that kind of idea? Okay. All right. I don't have any other questions. Thank you.
Just do whatever you're ready.
Good morning. Venturing towards afternoon, I'll try to be quick here, but there are some things that I still have to go over with all of you. Again, my name is Kim Jewell. I'm pleased to be representing Mr. Gary with Ryland Spitzer. We go over some of these fun. Who watches legal shows? I'm going to out everybody now. Okay. I don't, because apparently I've become too aggressive when I don't like how they're portrayed, because they aren't really that realistic. Because if any of you are expecting us to solve something in like 10 seconds, it doesn't happen. This is led up to this point. So if we are not as entertaining as television, is anybody going to hold that against us? Oh, thank goodness, because I'm already violating the black blazer on Monday in corporate world. So I've got to kind of watch what we got going on here. There are some other things that I need to talk to you about as far as who has heard Beyond a Reasonable Doubt. We've all heard it. You hear it on TV. Now, do any of you use that in your everyday life? Somebody tells you something, I don't think you've proven that to me beyond a reasonable doubt. And, everybody would look at you like, what is wrong with you? Well, we use that all the time, but I have to kind of go over it with you because that's not a term you guys use a lot. What does, and this is where I start picking on people. Mr. Nelson.
Yes, ma'am.
He's like, first one up. I like it though. You didn't even hesitate. You're right there with me. What does that mean to you, beyond a reasonable doubt?
You gotta prove that actually happened.
Okay. So if there are, let's say we'll pick 3 elements. If only 2 are proven to you, what happens?
Still gotta prove it.
Okay, so if there's 3 elements, 3 have to be proven. If there's only 2, has it been proven to you beyond a reasonable doubt?
No.
No. Where, as far as, you'll see evidence, the only evidence you'll be able to consider is what comes from this witness stand over here. You all can choose what to believe or disbelieve. So any witness, and this is part of why Ms. McAfee was asking about law enforcement, and some of you have law enforcement relatives. You will have to judge everybody that testifies to determine whether or not you believe they're being honest, truthful, straightforward. And you, as jurors, can choose to believe or disbelieve anything that's said up here. Do you all understand that you've got the power to do that? You have a whole lot more power than you think. Now, if you all hear the same evidence and you go on the back and let's say Miss Burnett and Miss Hester, you two disagree about what you believe the evidence has shown. Do you each understand? Because I like to let jurors know this. I've heard some absolute hollering coming out of jury rooms before. Do all of you understand that it's very important to treat each other with respect, even if you're in disagreement? And do all of you understand that you can bring your verdict out of a courtroom or out of that back room, whether or not you agree or disagree with someone else? Now, any verdict has to be unanimous. but you have the absolute right to stand on the verdict that you believe has been proven. Does everybody understand that? Does everybody promise me that you'll be respectful to your fellow jurors, regardless of any disagreements that you may have back there? All right. I love when everybody gets along. Who's heard of the presumption of innocence?
I think she was trying for one holdout juror.
Again, not something you use in daily life. Let's see. Mr. Weston, what does the presumption of innocence mean to you?
Well, you're presumed innocent until proven guilty, obviously.
Okay. So that means Mr. Gary's sitting over here in between two attorneys, and he is cloaked with a presumption of innocence. And that does not move unless and until the state proves by evidence. So and here's always a trick question. Everybody hates when I do it, but I'm going to do it anyway. Mr. Wood. You're like, here we go. If I sent you and everybody in the front row back into the jury room right now, and I said, you guys need to decide a verdict, what would your verdict have to be? Everybody agree with that? Because right now you've not heard anything. So if we sent you back there not having any evidence, not hearing anything else, that would be just one of the most rapid fire not guilties there ever was, because you've not heard any evidence. Now, if you hear evidence as to one element and then get shuttled back there, which there's got to be 3 proven, what would everybody's verdict still have to be? Not guilty, right? Because the state now, and that's something else I want to make sure everybody understands. I do not have to prove anything. And I know that sometimes strikes people. They're like, well, you're a defense attorney. Why don't you have to prove anything? Not my burden. The burden to prove this case rests 100% solely on the state. So if they do not prove to each of you, beyond and to the exclusion of any reasonable doubt, that all of these elements have been proven, it is your duty to come back not guilty. Does everybody understand? That's a high duty that you're taking on. And Judge is right. This is one of the biggest things as a citizen, and we appreciate all of you being here. And many of you have never sat on a jury before, and I know you're excited because at least some of you are going to be able to not say that anymore after today, because you will be jurors. Now, something I do want to also ask: would any of you, and I'm gonna preface it this way, there's an absolute right under the law that no one accused of a crime is required to testify. Says the Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his or her innocence. It is up to the state to prove the defendant's guilt by evidence. That is one of the laws the judge is going to give you that you have to abide by. Defendant exercised a fundamental right, may or may not, in choosing to be a witness. If someone does not testify, you cannot view that as an admission of guilt or be influenced in any way by that. That is also law that you will be given. Knowing that, do any of you, and if you do, all I need is honest answers right now. Does anyone have a problem if Mr. Gary was not to testify and say, no, state's burden, state has to prove it? Because it's so important, Mr. Anderson, would you have any difficulty with that? Or would you say, Ms. Jewell, I still think I need him to?
It's the way the system's set up to operate.
And for good reason.
Right.
Ms. Davis. No. Mr. Clackler?
No.
Mr. Nelson?
No, ma'am.
Ms. Schallenberg? Ms. Castillo? Mr. Wood? Mr. Britton? No. Ms. Hester? Mr. Peters? Mr. Garrikins? Ms. Burnett? Ms. Carbolito? Mr. Hayes? Mr. Oddie? Mr. Patel? Mr. Weston? Mr. Brotherson? Mr. Cash? Ms. Plow? Mr. Stafford? Okay. And I don't want anyone to underestimate the value of these rights, because in this room, that's what we're doing, is protecting rights. And they're not just Mr. Gary's rights, they're yours. Okay. That's why being a juror is so important, because you protect not only the rights of the accused, you protect your own. And that's kind of neat when you think about the fact that this is, what holiday are we celebrating this week? Exactly. You know, even though we don't daily think of the fact that we are, you know, either using our rights or things like that, you still hold those. And we have several of you that are former military, and we all thank you for your service, because you defended those rights, and they get defended in this courtroom too. So I don't want anyone to ever think that it is not extremely important what we do here. You know, we may talk and kid around about some things, but it's extremely solemn what we're doing in here. Okay. Let's see.
No jokes. We're very solemn.
Now, I usually like to wind up with this. Is there anything that you have heard, either, you know, beyond a reasonable doubt, presumption of innocence, whether or not somebody testifies, state's burden, any of that? Is there anything that during our conversation or a conversation with Ms. McAfee, or even one of the questions you answered with Judge, is there something that you're thinking, you know, now that we've had these discussions, no one's asked me this yet, but I think I need to either tell you something, or I've got something in my mind that you might want to know about, because we don't always touch on every question you have. Is there anything that is troublesome to anybody about any of the things that we've talked about so far, or just something in the back of your mind, you know, I didn't really mention this, but maybe they need to know this?
My retired husband has a part-time job, and he Cerakotes guns part-time.
Okay.
So.
Okay.
I thought she was going to say he
And
sells
thank
drugs.
you for that. Anyone else? No? Okay. I believe that is going to be all the questions I have. We appreciate it.
Thank you. Any questions?
I only heard one juror that's going to get excluded by the defense, and that's the one who has family that's law enforcement. I'm sure they don't want them on. But 2 juries are just getting selected. The cases are going to be tomorrow and the day after. They're both drug cases. We did see the last drug case we watched in this courtroom with this judge. There was a pro se defendant, no attorney, on his own, questioned the police officer, who I think was the only other witness, and I think there were 2 police officers. And he beat the case. They found him not guilty. He had like a pocket full of meth or cocaine or something. I forget what it was. And he beat the charges. It was an interesting experience for sure. I think the lawyers are conferring right now. I didn't hear any excuses. I'm not sure why, but we've seen other jury selections where you just have excuse after excuse for why people cannot serve on a jury. And usually it's going to be a case where it's like a murder trial or something that you know is going to take a long time, right? Here, a little possession under 20 grams. This is, it's a 2-hour case is what it is. It's really quick. So are you free in afternoon? Yes. But on the big cases where it's going to be weeks of testimony, you start hearing people come up with the weirdest excuses as to why they can't serve on a jury. I think there should be books, just lists of excuses. Fans still spinning in the corner, meaning the jury has not yet come back and told Judge Beverly that they are in fact hung. I would be surprised if they do come to a conclusion here. But getting reports from people in the courtroom that one of the jurors is very frustrated, visibly frustrated with this whole process for some reason. We don't know why. We can only guess what that means. Kim, I'm not sure what they're serving the jury for lunch, but I'm guessing it better be really good if you're actually holding out for lunch. I mean, I think I would rather just get my own lunch. Vampire slushies. Kaylee, just some basic questions. We just don't get to watch jury selection very often, so I wanted to watch that here. I think they're almost done. I think that or the judge fell asleep. Teresa Super just gifted a membership, and it went to Justin. Congratulations, Justin. Thank you, Teresa. The judge is watching a video of the fan spinning. He's mesmerized. Are his eyes open? Yeah, he's awake. He's awake. He moved. We're good. You can see the defense counsel over there talking with his attorney to see who they want to exclude and why. You think that a lot of people think that this doesn't matter very much, but this is a big portion of the trial. If you can get a jury that's more favorable, or you think is more favorable to your position, you've halfway won before the case even started. Living ghost, I love it. Teresa, I don't know how they would do that. How could you be on a jury that lasts for a year? I mean, part of the voir dire they do is on a long case like that, you've got to say, hey, here's what we expect for the trial, for how long it's going to last. Is that a problem for anybody? It's going to be a year and a half. Yeah, Judge, I think I've got something coming up that might conflict with that. Mr. Greeners, we can tell by YouTube history, you have nothing to do for a year. Interesting little stat there, AZ. People switch to the other team after they see what happens, how things are done. Well, I think we're about to take a lunch break once they seat this jury. That should prompt the jury in the Karen Reed trial to come back with another note. I don't see any jurors that are just like hopping to serve either. Joel's 04. There was a note this morning that the jury was deadlocked. The judge returned, brought the jury back and did the Tui Rodriguez charge and sent them back out to work again, and they've been out since then. So they've been out for a little over an hour since that charge. Maybe 2, coming up on 2. So that's the only note today. They don't have to reach a verdict. The judge would love it if they did, pushing hard for that. But they can't force them to reach a verdict. They can't force them to change their mind. Okay, it looks like we might have jury selected here. In that little process, the two sides listed anyone they felt should be excluded for cause, and when they felt they should just strike.
Ladies and gentlemen, if your name is called, if you leave your questionnaire in your chair and have a seat back in the courtroom.
Juror number 116, Claudia Castillo.
Just have a seat, ma'am. Leave your questionnaire. Have a seat back at the courtroom.
111, Under Clapper. 144, Bradley Britton.
These are the people who were not selected.
139, Anthony Peters. 132, Benjamin
Button.
Frankie.
Oh, not Benjamin Button.
126, Dana Burnett. And the entire back row.
And the entire back row. There are
Ms. Jewell, does that accurately reflect the jurors we've agreed upon?
Yes, Your Honor.
The potential jurors who are in the courtroom, thank you for your service this week. That will conclude your jury service. Before you rush out of here, I know everybody had somewhere else to be. This is a busy week.
Get your parking validated.
But these are important things that we ask you to do. And our criminal justice, our justice system overall relies on citizens for it to work. That separates us from the majority of the world. You have maybe 3 or 4 judges up here who determine the facts. Not in America. We have citizens that come in and make those determinations. Without citizens such as yourselves, our criminal justice or our justice system would come to a grinding halt. You have my appreciation, and you're also free to leave the courthouse. That's all the jurors we're going to pick this week, juries. So have a good week. Happy 4th of July. All right, ladies and gentlemen, you've been selected to try this case. We're going to try it on Wednesday. We're going to start at 9 o'clock. Ask you to be back at the courthouse no later than 8:45 on Wednesday morning. That's the 3rd. Come into the front where you came in today. Have a seat there in the lobby. Do not come to this side of the courthouse until you're all together, until you're escorted by the Bay County Sheriff's Office. Do not discuss the case amongst yourselves or with anyone else. Don't check any media sources, such as a radio, television, or newspaper. Don't use your electronic devices to find out any more about this case than you know right now. And I may have already said this, don't discuss this case amongst yourselves or with anyone else. You'll wait just a moment. I'd like for you to follow the clerk out to the courtroom, and she will get your contact information. After she has your contact information, you're free to leave. Leave your questionnaire in the chair. Thank you. Where you are. Thank you. Thank you. Thank you. All right. If you'll follow the clerk out.
And with that, we have a jury selected. I'm not sure if we have any other business to do here in court, so we might take our lunch.
All right, everyone can have a seat. We still need to, when the clerk gets back in, we'll need to address Simonano, Ms. Jewell. Is there anything else we need to address with Mr. Gary?
Your Honor, he had a question for me, but aside from his question, I think that's not pertaining to anything the court would need to determine.
Okay, can we go ahead and take him back in the back? Or you want to talk to him just for a second?
If I could just talk to
Yeah,
him.
absolutely.
He's in custody. He's in custody for a possession of less than 20 grams. There's got to be something else. Either he's got other charges that are holding him, or I have a spare cell phone that's just turned in. We are seeing that news out of the Young Thug trial, that it's sort of on hold for the moment while the judge has another judge look at the case. Or look at the ex parte meeting anyway. See if we can go back and see what that ruling was. Let's see if we can. We canceled the hearing for Attorney Bumpus. Let's check this out really quickly. Give me just a second. Let's see. Let's go to 7, shall we?
Considering whether or not to have an in-camera discussion or review of the records, this court has decided to release the entirety of the transcript of those proceedings as courts won. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that'll be marked as Courts 2. So the transfer will be Court 1. His immunity agreement, Mr. Copeland's, will be Court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations, during the proceedings on Friday, June the 7th, which will be marked as Courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be Courts 4, Mr. Copeland's order of contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings, as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Miss Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Miss Caleb Bumpus, attorney or ADA Miss Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were Attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, Deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall. The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with Attorney Bumpus from 10:17 a.m. to 11:28 a.m. The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m. The court arrived in courtroom 1C at 11:49. The transcript of those proceedings, starting as of 11:49, or when the court presumed that held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m. A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking then Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams. The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told to him at that time. Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m.
I've never seen a judge play
The court
CYA
asked Mr.
like
Steele
this.
again whether he received ex parte information, and that would be at 5:59 p.m. Mr. Steele's counsel, Ms. Ashley Merchant and Mr. Alex Susor entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as Court 6, and the proceedings concluded at 7:41 p.m. The court further takes judicial notice of the following statements proffered by Attorney Brian Steele, in open court.
Stephen, congratulations.
Upon information
Chris,
and
thank
belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of Courts 5, the proceedings that are held on the 10th of June of 2024 in courtroom 1C, which the court has already said will be part of this order. The first assertion and the transcript bears out exactly what Mr. Steele said, so the court is paraphrasing the 6 assertions that Mr. Steele made. They're more aptly and more eloquently put in the record. The first one...
Mr. Steele was quite eloquent.
involves his concern that supposedly in chambers, this honorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies, Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present. Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment.
There's Mr. Steele.
Third assertion is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage. and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas. At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp. The court in no way sought to investigate any facts of this involving this footage, and it only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers, not for whether or not that was truthful or not. Mr. Steele makes further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was, the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage.
Those chairs are in such bad condition.
No, Mr. Copeland was a sworn witness, and third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9.
Yes, they are.
Which I'll take judicial notice of, which
now he notices.
In pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication, and the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver. And all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit.
I need that document. If we can get Amber.
In this
Amber
particular, and then the last part of 2.9 before the court goes on.
Transcript
if
of the meeting.
Involves in pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit, and before any other further examination of Mr. Copeland. I'll address the issue of the emergency nature of this particular hearing or this particular conference in front of the court, is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-507. And that the conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating, along with Ms. Bumpus, his lawyer, who's there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court has taken into account a couple of cases I'll cite for the record.
Karen, thank you so much.
One of them is
10 months.
United States versus Adams, and that's 785 F. 2nd 917, decided in March the 31st of 1986. In pertinent part, presence of the accused. Although an ex parte conference to discuss threats against the witness is proper, district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed. And in Adams, the appellants contend that the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations the trial judge may find an ex parte conference necessary. They cite La Chapelle, and that's LACHAPPELL versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983, where the court cites, in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about a threat. A witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant. We agree with the First Circuit that an ex parte conference is appropriate in that situation. They see United States versus Arroyo, and it's ANGULA. It's at 580 F. 2nd 1137, pinpoint 1142, 1142, 1141, 1142, Second Circuit case. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. And they've got a citation for that being 439 U.S. 913. Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed. And second, the entire conference was transcribed.
Mel, thank you so
That's
much.
United States versus Watchmaker at 761 F. 2nd 1149, 1985. Ex parte conference with frightened juror properly were transcribed and the judge's comments carefully framed. This court goes on to say in Adams, two aspects of this conference, however, are disturbing. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pulley took the stand. Defense counsel inquired about what inducements had been given for Pulley's testimony, and the prosecutor and Pulley both indicated only promise was that the prosecutor would seek to enroll Pulley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pulley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed. Similarly, in this matter, the only thing discussed between the state counsel for Mr. Copeland and this court were the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to that were induced or sought by the court. And the transcript in its totality will bear that out, and you can have a look at that. The court's also considered Bruner versus the state. That's 302 Georgia at 6, and this relates to the right to be present and what is defined as a critical stage and under the Sixth Amendment. Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present, see and hear all the proceedings which were had against him on trial before the court. Ward versus the state, 288 Georgia 641, pinpoint 645. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring a new trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. And that's Huff versus the state, 274 Georgia 110, pinpoint 111. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost, defenses waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way. And in this particular case, the court is of the opinion, basing on looking at the case law, that that this was a proper ex parte meeting pursuant to 2.9.
Melissa,
as
it's
well
cheaper
as
for you.
The,
it doesn't change anything for me.
no
Computer
party
makes it
gained any
cheaper for
tactical
you.
advantage, and that the proceedings as a whole are released to will be in the terms of the transcript. So what was said can readily be seen and utilized by the defendants. Okay, and the court lastly took into consideration Talton versus the state. That's 368 Georgia Appeals at 313, and that involves a Sixth Amendment critical stage definition that was decided June the 21st of 2023. And in pertinent part, in many instances, remand will be necessary when the right to be present claim under the Georgia Constitution is raised for the first time on appeal from criminal conviction. So Mr. Seals raised this at the appropriate time, and the court is in fact considering it. And the Georgia Constitution guarantees criminal defendant to be present, see, and hear all proceedings in which are against him on trial before the court. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where a defendant's presence would be useless or benefit but shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law and consist of essentially legal argument about which the defendant presumably has no knowledge. It is well settled under the Georgia Constitution guarantees a criminal defendant the right to be present and see here all the proceedings in which are had against him or trial before the court. It's Prickett versus the state, 314 Georgia, 435 at 441 pinpoint. This right attaches to any stage of the criminal proceeding that is critical to the outcome of if the defendant's presence would be contribute to the fairness of the procedure. But the right does not extend to situations where the defendant's presence would be useless or benefit or shadow.
Judge is doubling down, saying he was in the right. He's releasing everything, making the announcement right now.
The court further takes no position on whether Attorney Bumpus disclosed confidential or attorney-client matters. The court takes no position on whether Attorney Bumpus violated the duty of candor to other counsels involved in this case. These two questions can be resolved by the State Bar of Georgia and or our Supreme Court.
Oh, they're stepping
out now. The court further takes no position on whether Mr. Steele, his use of the June 10th proffered information, as his use on behalf of Mr. Williams falls within our guidelines as set forth in the Georgia Rules of Professional Conduct.
So he did everything right.
The court's basis for having been explained on the record, a written order of this, along with the attachments, will be included in the record. And Mr. Banks, where are you? Sir, as a result of this transcript release, the court withdraws the show cause for your client and others who may be present who are present in chambers on the 10th of June of 2024. And as I mentioned earlier, we were going to have a show cause hearing on Wednesday, the 3rd of July. I am canceling that indefinitely. In fact, I've canceled all of that. So we will not be holding that particular hearing. Wow. Okay? All right.
He's backtracking.
And then then transitioning to the last matter the court wanted to put on record. Upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So
another judge gets to look at the
written
motion
order is entered. I will enter the order transferring it. And until such time as those two things are decided,
and now we're done.
Then
we can't
we'll be
move
in
forward.
recess
Yeah,
until
we can't
that
do
time.
anything.
And we will just inform our jurors that they're until this is. They're not supposed to come back on Monday until Monday anyway. So I will have Deputy Ingram and Ms. Umana indicate to them that they are still on recess and we're continuing to work. So that's all I have for you at this point in time.
I need these documents as soon as they drop. I'm not sure where they're at. I specifically want the transcript. We're going to read that together.
Ms. Novi, can I ask you a question before you start anything? Madam, didn't your law firm represent one of the co-accused in this case? How are you then? Do you have an actual or perceived conflict in this case? No. Have you been? I'm asking you at this point in time. Could you state for the record how it is that you don't think you have a conflict, because you did represent one of the co-accused in this case, correct?
I did.
Okay.
I did. He's been discharged. Your Honor, this has absolutely nothing to do with my representation of Sergio Kitchens. Haven't even discussed that or come up and what happened in the ex parte proceeding. We're just representing Mrs. Bumpus, Attorney Bumpus, in what her position is.
Still mad.
Is I on mute?
Yeah, you're good now. Yeah.
With respect to this court. So completely different matter. And now we're dealing with a contempt hearing of Miss Bumpus as opposed to a criminal prosecution of Mr. Kitchens. Completely different. And in fact, everything that we've gone through or anything we've learned about this case has nothing to do with what we've done with Attorney Bumpus.
Okay, I just want to, because you may have an actual or perceived conflict. I just wanted to bring that to your attention. So if you think that it should be addressed, then I'm giving you the opportunity to do so at this point in time. Because you do have knowledge of this particular case, but all right.
Well, I think half of America has not. I said I think half of America has knowledge of this particular case at this point.
But they're not before us at this point in time. So what else did you want to?
Well, and I'll speak for the court's purposes. I'll speak for myself and John Garland, who's also our co-counsel with Attorney Bumpus and who was my co-counsel in Mr. Kitchen's case. All right. So I'll speak for both of us in that respect since Mr. Garland's not able to be here.
All right.
A couple things that I just wanted to clarify for Your Honor. Is the court still intending to produce an order on what the court addressed orally on our recusal motion?
Yes, ma'am. I'm going to produce an order basically bundling all, since there are 3 motions to recuse, to one to be spun on the wheel so that we don't get 3 separate people hearing these particular matters. So I will do that effective today.
Okay.
So does that answer your question?
It does with respect to that. The other issue was I think the court was holding under advisement our motion to quash.
That makes this moot at this point in time.
Okay. So
since I'm not going to have a hearing at this point or at any time in the future, you can re-raise it at that point in time if you so desire.
That's fine. So
I'm telling you at this point in time, I have no desire to resolve that. I don't need to at this point in time.
Okay. All right. Those are the questions that I had.
Okay. All right. Madam, unless you have anything else, you all can be excused. Counsels, I'm going to go ahead and, like I said, work on this particular order. I actually memorialized the order in writing and the motion to recuse in terms of sending it to another judge pursuant to 25.1 through 25.7.
Which is what he was supposed to do initially.
We'll see in a little bit, depending upon how it's ruled upon, all right? All right.
Your Honor, do we have a timeline of when the motion to recuse may be heard?
Don't know. That has to go to another judge pursuant to our local rules. So it will be basically put on the wheel. Of course, I don't have anything to do with that.
Right.
So as soon as our clerk, Madam Clerk, Miss Alexander and her team spin that, that's not within my
Do they have a literal
information
wheel?
and
They
purview.
spin it and see who.
Is this something that we can expedite? I mean, the state does have very concerns that we hold the jurors indefinitely regarding this matter. Is there anything that could be expedited so that those decisions can be made on the motion of recuse and we can move forward with the trial?
While I understand your concern, I think the rules of transfer and recusal are pretty clear. That I'm not going to comment on anything that is pending at that point in time. So hopefully it will get done fairly quickly in terms of somebody acting on it. Okay.
All right, thank you, Your Honor.
Okay. Anybody else? Mr. Steele, you rose just a second ago. Do you want to say something, sir?
Oh, yeah.
Okay. All right. Okay. Okay. Then we're in recess and we'll see you in a little bit. Okay. All right. We're in recess.
Wow. Okay. So that was a complete reversal. Samantha, thank you very much for the link. Let's see. Send this over to 3. You don't happen to have the case number as well, do you, off the top of your head? The complete reversal. What happened in this case, the judge was on a power trip. He did something that looked like it wasn't right. I don't know. I would say my gut feel was it wasn't right. He had an ex parte meeting where he met with a witness that was sworn in at the time. He was on the stand, like not literally he was sitting on the stand, but he had been sworn in. He had not been released yet from that testifying. He met with that witness's lawyer and the prosecution without any of the defense knowing anything about it. Thank you, Greeners, for that case number. I appreciate that. They should have known But instead of telling them, he got really mad when they found out anyway. And instead of addressing the issue that shouldn't happen, and there could have been some coercion involved and everything else could have changed the testimony. Instead, he tried to chase down where the information came from to find the leak. Issued show cause, called a show cause hearing for Attorney Bumpus, who would quit immediately after this. Issued a contempt order for Attorney Steele, who brought it to his attention and demanded to know what happened in there, and even went so far as to have him taken into custody and ordered him to serve the 10 weekends in jail. Turns out the higher court put a stop to that, so he never actually served. But we did see him take off his jacket, hands behind his back, get let out of court. Just epic stuff. Now, everyone has basically said, hey, we're all on the same page here, Judge. We think you were wrong. They filed all the motion to recuse the judge, everything else, and he flat out just denied them. The rules state that he has to do different things a little bit differently, and now he's sort of going back and patching that up. The meeting where he was going to find where the mole was, he's canceled that. He's not interested in doing that anymore. Wonder why, right? He's basically just smoothing things over. Because of this, all the rest is sort of, it's moot. Don't worry about it. Another judge will look at this. They'll rule on whether or not he gets recused or not. And then we're going to come back and continue. If he does get recused, it's a new judge. It's just a swap to a new judge. I don't think that will end in a mistrial. How would you like to be the new judge that just adopts or, is awarded this case? I would quit if I were them. Right in the middle of this one. This one is such a mess. Such a mess. Greeners, was that? I was about to copy that down. 8675309. Literally, I was thinking, that's weird. Georgia uses a weird style to call their cases. Jeffrey Williams. Georgia v. Jeffrey Williams is the case number I was looking for. The judge also did say the transcript of that meeting, that ex parte meeting that no one's been able to hear about, that he's refused to release, he is releasing it now. So he's had a change of heart. In addition to everything else that's going on, he's releasing that. He says it was a short meeting, much shorter than we were led to believe, and I think those will be public record, or they were going to get leaked through the attorneys that received them. Yeah, I see what you did there, Vicky. Everyone's just piling on now. Anyway, good times all around. We are still watching the fan spin. By that I mean we're waiting for a result here. I think we are officially in the lunch hour, so we're going to take about a 40-minute lunch and come back at the top of the hour to see if the jury has an answer as they come back from lunch. But taking forever. Instinctively Correct says, I missed you all on my 1 year, 2 month, 3 day, 123 anniversary on Friday. Sneaking in on my lunch break to say hi and miss you all. Instinctively Correct, thank you very much. 14 months, 123 anniversary. That is just great. Thank you so much. It wouldn't be the same here without you. Hope you get to come back often. Let's see. Whoa. Allie, different. I think you're mixing them up, Allie. The Sarah Boone judge, we've got Judge Kranick, who is the new judge for Sarah Boone. He has not withdrawn. The judge in Sarah Boone has ordered that Sarah Boone is no longer entitled to a court-appointed attorney, so she cannot get free court-appointed attorneys. She has swiped left too many times, and now she has to buy her own. But so we've still got. We have a new letter. We have a letter. We have a letter right now from Sarah Boone. It just barely dropped. Hold tight. You guys, we have a letter to the judge. Whew. I need some music. I almost need verdict music. How about this? We'll do verdict music because we've missed out on verdicts forever. Sarah Boone, Pro Se Sarah, has written the judge. We have a brand new letter that just barely came out. It's still, I think the ink is not yet dried. Ink is not yet dried, but we have a letter. We're going to bring it to you right now. Wow. Let's see. Change the view here. I think we're good. All right, here we go. This is dated June 25th. This takes us back just a little bit. Here we go. Oh my goodness. It's straight to the judge. Dated June 25th. Deep breath, everybody. Deep breath. All right, we got a letter. Honorable Judge Michael Kranick from Sarah Boone. Your Honor, it was made known to me by an officer here at Orange County Corrections Department that my attorney, Patricia A. Cashman, has submitted her motion to withdraw on 6/11/24, which now explains why she has not contacted me nor answered my calls. Why hasn't anyone sent me a copy so I know, to confirm my exclusion in my case, especially by attorney Cashman, and stated in all my letters previously written, I was not included and I'm finding out weeks later. Judge Kranick, I am trying to receive, please, a copy of her withdrawal to better understand her reasons for the undisclosed departure from my case. No attempt was made on her part to solve or remedy in some type of discussion professionally beforehand. Therefore, I am having to include you for this request, as I did with my most recent letter. Please understand. I am trying to understand. With her attempted withdrawal, my very legitimate concern now is not having all my case contents returned to me. As with host of the prior attorneys, to date, many of my evidentiary case items cannot be located after my numerous requests to the attorney on my case at that time and to attorney Cashman. No one knows where my case items are, who has what, or cares to research and return now that I am no longer under their representation. Shrugged shoulders, avoidance, and lies of where anything may be is all I have received when requesting from former unwilling, disingenuous attorneys. These are my case documents. Attorney Cashman stated to me more than once from me asking repeatedly about that she had received all of my discovery, which I was withheld from viewing. Also, so I do not even know all she had specifically and completely and what was available to me. Your Honor, how can I ensure, please, the return of all my case contents from the attorney Cashman? Oh, she's going to get it all. When I finally review my discovery and the contents she has of my case, so I know what is still missing or lost. Pardon me for having to utilize your invaluable time to ask to receive my invaluable case items. Please understand, I am trying to understand how and when I can fully, rightfully defend myself. Your day has come, Sarah. It's today. Due process is due. Overdue. I thank you in advance for my inclusion to also receive a copy of Attorney Cashman's withdrawal notice and for helping in the ensurety of all my case contents to be returned successfully for my historical review from Cashman. All other former attorneys also, please, if possible. Judge Kranick, you will never understand my gratitude for listening to me. Give me opportunity to finally be heard and your apparent caring judicial manner. Thank you immeasurably. I await the next appropriate step in moving forward, however, and with whomever. Sincerely, Sarah Boone. She doesn't know. For inclusion futuristically and to ensure receipt of all correspondence to me in my case, my address is as follows. There's Sarah Boone. I am also including Attorney Cashman with a copy of my letter, mailing to her. And there is she does not know at the time she heard her attorney withdraw, and she doesn't realize that she is not getting another one at the time she wrote this. I mean, she knows now. But she says in here, oh my goodness. No answered calls. Why is my attorney not calling me back? Because she quit. Look at this. Pardon me for having to utilize your invaluable time. I can't get this to highlight here. There we go. When can I fully, rightfully defend myself? Oh, Sarah. You are pro se. All your case items will be delivered to you in 2 cases, plus 2 more depositions that Attorney Cashman did for you. It's all coming to you, and then you are on your own to defend yourself. Because the $5 that has been raised in the GoFundMe, I believe tongue-in-cheek, is not going to pay for a lawyer. 5 of the 10 million that she's hoping to get. Oh my goodness. Oh my goodness. This is crazy. So the court, she sent this letter on the 25th, and then she showed up in court, and the judge must have had this letter. It takes a few days. So the judge had this at the time the decision was made. Let's see, because it was filed, it was stamped 6/28/259. That's when it was filed. So I think the judge had it and stamped it with the rest of the decision. Well, she got her wish. She gets her boxes and she gets to defend herself. Her time is now. Wow. Wow, wow, wow. What a way to go to lunch on that. Delivered in 2 cases. No, just boxes. Banker's boxes, unfortunately. That is crazy. Well, all right. On that note, we're going to go to lunch. We had just a brief little letter. I expect another. because that was the last time Sarah Boone wrote before she realized her lawyers she would no longer have a lawyer. She is on her own. Now, anything she writes may actually be treated as a motion because she has represented herself. So it's going to be handled a little bit differently with the judge going forward. But I still think it's going to be filed and crazy. All right. We're going to go to lunch. We're going to take a little bit of a break, only about half an hour, because we're going to be back here at 2 just to see if there's any motion in the court as we're waiting to see. So we're waiting to see what happens here if the jury gets a verdict in the Karen Reed trial. So we have been bouncing all over the place, Kelly. You've been motion sick. I know. I'm sorry. It's been a little wild today. We've been a little bit of court hopping, jumping around here and there. Now we've got Sarah Boone letter, Karen Reed verdict watch, probably a hung jury. Lots and lots of stuff happening today. And we have some new cases coming up as well, so we're gonna be watching out for those. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again, which will be in about 30 minutes. First person in chat, as always, is going to be awarded the internet. Greeners won this morning, just about won it with a super chat, just to rub it in. So, thank you all. Be good to each other. Have some lunch. We'll see you back here in about half an hour. Bye-bye.